Okay, good morning, everyone. Thanks for coming. My name is Jay Thomas, and I am a member of the law faculty at Georgetown. So I have to say, it's a dark day here at the Law Center. It's a sad day. Our beloved Hoyas lost over the weekend to the University of Utah. So we need an event that's going to inspire us and bring good cheer. What better than a conference on patent law? So here we are, and it's going to be a very exciting event. I'm looking forward to all the panels today. We've had a few of these now. I want this to be our best one yet, and I'm very thankful to our partners at WilmerHale for helping to bring this together. And having said those few words, I'll introduce our Dean, Dean Traynor. Thanks for coming. I hope you'll be able to welcome us.
Very good. I'm Bill Traynor. It's great to see you here. Jay wanted to make sure that we started exactly at 9 because, as he said, a timely conference is a strong conference. So welcome, and thank you very much for being here. This is the third year that we've had this conference, and we're very, very proud of it as we look at the changing patent landscape. And as you all know, with so many changes to the patent system in recent years, events such as these allow us to take stock of current circumstances and also to think through our prospects for the future. So we're very proud to be able to co-sponsor this with WilmerHale, and it's a privilege to welcome you here. One of the things that I think is kind of most important for every law school right now is to think through how we prepare students for the way in which technology is transforming legal practice, and the way in which we take advantage of the practicing bar to help us think through what the opportunities are. And so, since I have you here, I'm just going to do a very quick infomercial for us and how we're thinking about that at Georgetown. This is an area that we've always focused on, and in a very concerted way, this is the area in which we've really chosen to grow, the area of law and technology. And I just think there's really no area of the law in which technology isn't transforming practice. I mean, that's obviously the case in patents. It's the case in areas of the law that didn't exist a few years ago: cybersecurity, privacy law. And there's really no area of the law in which technology isn't transforming even the most traditional areas. Think about it in employment law. Somebody works for Uber. Are they an employee or a contractor? So there's really no area in which law is not being transformed by technology. And so we're thinking through how we're on the cutting edge of that. It's very much where we're focusing our faculty hiring. So joining us next year, we're going to have kind of two faculty members who will be joining Jay and Rebecca Tushnet and Julie Cohen and Tanina Rostain and Laura Donahue in the law and technology area. Neil Sukhatmi is joining us. He's originally a patent lawyer who just is completing a PhD in economics and physics. In economics at Princeton. And we've also hired Paul Ohm from the University of Colorado. And Paul is one of the nation's foremost experts on technology and privacy law. And significantly, he worked as a computer programmer and network systems administrator before going to law school. And one of the things that he's taught at Colorado and that he'll be teaching here is writing code for lawyers. And that's part of a larger focus that we all have to have, which is, how do lawyers come to understand technology? Obviously we have people who come out of an electrical engineering or a computer science background, and it's easy for them. But it's something that everybody's got to know. So just to give you an example of other initiatives that we have, Tanina Rostain is a faculty member who's teaching courses on designing apps for lawyers. So each of the students in the course has as a project designing an app, and it could be on analyzing minimum wage law or veterans benefits or Social Security law. And the students learn the law as they think through the decision tree, and then they design an app. And then at the end, we have a panel of technologists and lawyers and faculty to judge the app on which is the strongest on best all-around design, most excellent in presentation, and best all-around app. it's a new area for us, but it's preparing students both to be legal technologists and to understand what the opportunities are. We also started a center last year on privacy and technology that's headed up by David Vladeck, who's headed up consumer protection at the FTC. We brought Alvaro Bedoya from Senator Frankel's staff to work on the center. And they're doing things like, right now they're looking at legal issues involving technologies that digitize our offline selves, like healthware apps or biometric identification techniques. And again, they're focusing on educating the next generation of students. So they have a great course that we're running with MIT, in which Georgetown law students and MIT computer science grad students work together on coming up with draft regulations, draft statutes, and then at the end of the year, they come and they present to administrators and people on the Hill the legislation, the regulations that they put together on areas like biometric identification or what we should be doing with respect to healthware apps. So, again, the big idea is trying to think through in every area how you prepare students for a very changing landscape. We're very proud of all that we're doing, and we're particularly proud of this conference. It's a great program, and I want to thank Jay Thomas, who does an amazing job in putting this all together, and really has done so much to put us on the cutting edge. So thank you very much. I'd like a round of applause for Jay. We have a great CLE team who puts together all the logistics. Jill Castleman, Larry Center, you saw them as you were coming in. So I'd like to thank them. And then I'd like to turn matters over to Jay, who will introduce Don Steinberg. But the final point is, when I was dean at Fordham before I came here, and Fordham has a big international intellectual property conference every year. And the motto is that we wanted you to learn, debate, and have fun. The same goes here. Okay, so everybody learn, debate, and have fun. And welcome to Georgetown.
Well, let me just briefly introduce Don Steinberg, who's co-chair of the WilmerHale Intellectual Property Group. The remarks were really overmuch because, in fact, WilmerHale, I think, did all the work. But we'll see. So, Don, come on up and introduce us. The best part, even though he's done so much work for this conference as a co-chair of the Intellectual Property Group at WilmerHale, is he, in fact, has a child who's matriculating to Georgetown Law in the fall. So thanks for the support. We appreciate it.
Glad we could help. Yeah. Thank you. Thanks, Dean Traynor. Good morning to everyone. It's really a pleasure to be here. I'm Don Steinberg, the chair of the Intellectual Property Department at WilmerHale. We've been really delighted over the years to partner with Georgetown University on this conference. We bring together, we hope, a distinguished collection of leading minds from academics, from industry, and from government to talk about the latest developments in intellectual property law. Each conference, we try to provide some useful updates on major developments, but also identify some of the new trends and influences. And we hope we've succeeded in that today. I guess we'll find out over the next couple of hours. Today's conference features 4 different panels addressing a range of topics. For those of us who work and practice in the area, should be very interesting, I think. The first panel will explore post-grant review proceedings during the first 30 months of the America Invents Act. I'm not sure if that seems like a lot of time or a little time, but the post-grant proceedings, I think, have really significantly changed the patent landscape and litigation. We'll hear a little bit about that in a little bit. And they'll be talking about whether these proceedings have really served their intended purpose and which strategies are proving most effective both for petitioners and, of course, patent owners. Our second session focuses on keeping up with developments abroad. enforcement of intellectual property rights increasingly features global strategy and the ability to coordinate across many different jurisdictions with different laws, different practices. As we're all aware, the Supreme Court continues to issue rulings in key areas in intellectual property, such as what constitutes patentable subject matter, the standard for awarding attorney's fees. And the Federal Circuit continues to develop case law in important areas, such as damages and the ability to obtain injunctive relief. So we're pleased to have Mr. Nathan Kelly, Deputy General Counsel for Intellectual Property Law and Solicitor from the U.S. Patent and Trademark Office, here with us to facilitate a discussion on developments in patent law at the Supreme Court and the Federal Circuit. And then finally, I'm happy to announce we'll conclude the conference today with a lunch featuring our keynote speaker, Representative Daniel Issa, Chairman of the Subcommittee on Courts, Intellectual Property, and the Internet, the House Judiciary Committee, and the House Foreign Affairs Committee. So let's kick off the program. Let me introduce our first panel of the day. We have Q. Todd Dickinson, former Undersecretary of Commerce for Intellectual Property and Director, U.S. Patent and Trademark Office. Kim Schmidt, Senior Litigation Attorney at Intel. James D. Smith, Board of Patent Appeals and Interferences, Chief Administrative Patent Judge for the U.S. Patent and Trademark Office. And our moderator, my colleague Dave Kavanaugh, a partner in the IP department at WilmerHale. So thank you again for choosing to spend your morning and early afternoon with us, and please join me in welcoming our speakers.
Your Honor, good to see you this morning.
Thank you, Don, and thank you, Dean Traynor. Thank you, Jay. And I want to also welcome everyone. This morning's panel, the first panel, is related to post-grant proceedings, and it's something that I think everybody on this panel, whether as a full-time job, as Judge Smith has, or as a kind of a large part of our practice, as the other panelists have experienced, is something that is changing the way we think about intellectual property, about strategies, and the developments are affecting how we are kind of looking at advising clients, how administrative proceedings are conducted at the Patent Office. And with that, I want to kind of guide a conversation with these esteemed panelists to understand from their perspective some of the things that have been so groundbreaking in the developments in post-grant proceedings. And kind of just to frame the conversation, and before I introduce or into the panelists' comments, there are a couple areas that we want to describe. The statistics, and we don't want to focus on the numbers per se, but we'll use that as a vehicle to talk about the proceedings themselves. Rule changes at the post-grant proceeding, and
Thank you.
IPRs, inter partes reviews as a part of a litigation strategy. What is the experience in the industry, in the legal industry? What is the experience of different companies? Want to touch briefly on strategies related to patent owners and what to do if They are, if a patent owner is has a patent that is an inter partes review is filed upon. And then finally, some comments from the panelists about IPR terminations. How do they end, and what does that mean for kind of both the process, both from an appeal perspective, but then also thinking through settlement issues. So with that, I wanted to just introduce a couple numbers. There have been 2,600 IPR petitions filed, 315 covered business method petitions filed. We see a number of statistics. They're in your, or a number of data points. They're in your package. And I guess my first question would be to Judge Smith. And, you know, as the panel is framed, are the post-grant proceedings a success? And my question would be, given the number of filings, is there any kind of thought that you have regarding they're certainly widely adopted, and I was wondering if you could share any thoughts you have with regard to the proceedings being successful.
I'm not sure I'm the right person to answer that question. I think at the Patent Trial and Appeal Board, and let me just note, at one time I was Chief Judge of the Board of Patent Appeals and Interferences and had the privilege of being its last Chief Judge, but we are under a new name now. And with the new name, of course, new responsibilities. I think if we were 3 years into the post-grant proceedings and no one wanted to file, that would be its own statement, I think, of lack of confidence in what the board is doing. So that would certainly be a clear indication of lack of confidence in or a vote against there having been success. At the same time, I don't think, given the overwhelming number of filings, that we conclude there has been success. Of course, one criticism of the proceedings and a counter indication perhaps to success is that too many petitioners are winning, patent owners are having claims declared unpatentable too often, and that the great number of filings is its own indication of lack of success, if not in the way the board functions, in the overall development of the law with respect to establishing unpatentability. I think it may be a little too early to tell whether there definitely has been success. I think the percentages as to who wins and who loses, those are evolving, so we will be able to draw more from that. I would say there is one respect in which I think the board is clearly successful and the process has been successful. And this is, in some respects, a micro slice of the overall picture, but I think it's an important slice. If you read the decisions of the board and just try to evaluate them on the quality of the legal reasoning, the writing, how the mission as interpreted is being executed, I think one does see success.
Thanks. Todd, I'm wondering if you might be able to share your perspectives on.
First of all, I'm now a partner at the law firm of Novak, Druce, Conley, Bove, and Quigg. We have clients on all sides of these issues, so I want to start off by saying that these are primarily my thoughts and shouldn't be attributed to the firms or our clients. I think it's useful maybe to look back at a little bit of the origination of this during the debate over the AIA. The primary debate at that point came out of the primary recommendation of the National Academy study, which said that there needed to be a more robust post-grant process, somewhat akin to the opposition system in Europe, that would enhance the quality. And their goal is to enhance the quality of patents overall. And so much of the debate in those earliest days was actually first surfaced this sort of technology versus technology debate, where you had folks like the high-tech community urging a wide-open process throughout the life of the patent, where any grounds could be used, kind of like CBM is structured today. You had others, biotech and pharma would be a good example, who didn't like post-grant generally, but would agree to go along with it if it was a very narrow process just coming out of the opposition system, where just for a period of time, brief period of time, as it came out of the office, the patents would be available for that kind of approach. They went by the nickname, the first window and the second window. Almost all the attention was focused on the first window. The second window, in large part, was just viewed as, frankly, changing re-examination around in a few ways, changing the standard a little bit, moving from having the examining core do the re-exam to having 3-judge panels decide the issues in that second window. And the second window evolved, obviously, into what's now the IPR. So the extent that I think folks believed it was going to be a simple conversion of one to another and may or may not have been used that much, we've been proven wrong. Obviously, as Chief Judge Smith said, the numbers don't lie. I think the budgeting number originally was something in the order of 500, maybe to 1,000 of these, and we've obviously exceeded that substantially. Whether that means it's a success or not, I think, is a question we're in debate today. I think there's strong concerns that have been raised about the rules that were adopted. I think there's strong concerns about how the rules have been interpreted by the board, and whether or not that means that we have, even as far as to say due process in this process, is now something of a debated question. So I think to the extent that the numbers suggest success, I would argue that no small part those numbers suggest a confidence in the outcome, by and large, that may or may not be the fairest way to approach this process. As the chief, to quote the chief judge who quoted another chief judge, we wouldn't be doing our job if we weren't doing a little bit of death squatting.
Please allow me to comment on that comment, which now has been quoted. When I made that remark, it was in response to whether there were concerns about the PTAB serving as death squad, providing death squads for patents. And the first part of my answer, somewhat now less quoted, was definitely not. But I also wanted to point out that if, in fact, patents with claims with unpatentable subject matter, which is just the claims which should not have achieved a determination of patentability, came before us, we would not be declining to do our job and indicate those claims were unpatentable. Perhaps it's unfortunate that Chief Judge Rader used that language to begin with, and I only compounded the problem by using his language. So I will henceforth cease the doing of that.
I think another, just to briefly comment, though, on the numbers, and we may get to this number, which give rise to the questions that have been raised. Under re-exam, roughly 20%, 15, 20% of patents were killed, where all the claims are held invalid for one reason or another in re-examination. 80 to 85% of them, either they were limited by amendment or they were held valid in their entirety. At the moment, I believe, the PTAB is ruling, is finding invalid the independent claims, most significant claims, in somewhat north of 70 to 75% of cases. So I think there is a change, at least in that regard.
Great, thank you. And Kim, I'm wondering if you could share some insights from industry on kind of the use of IPRs, what your expectations have been, and whether or not those expectations have been met by the current process.
Sure. So just to give you a little bit of my background, I've been doing patent litigation for about 15 years, and I'd say probably 85 to 90% of that is on the defense side. So I might come at this with a little bit of a bias when I say, when I look at IPRs and when I'm asked if, is the process successful? Heck yeah, it's pretty good. Especially if you're looking at it from a defense side. Now, I say that. This is my own view, not the view of Intel Core, but I think these things are a successful and much needed process in the whole litigation system, because we have, with the IPR process, an opportunity to get clarity on the claims, to get clarity on the property right that people are asserting early on in the process, and that encourages settlement. And I think, by and large, people would agree that an earlier settlement is a more efficient use of resources. You're not taking up as much time in the courts. You're not taking up, you're not spending millions of dollars on discovery fights, on claim construction and experts. You can get some resolution early on through the process by understanding better what it is that's, what these claims are limited to. And the prior art being presented to a patentee often invokes a response, a narrowing response on the claims, where you can get some clarity and you can get people to the table sooner. So I think it is a success.
That's good. Thank you. Moving to the different technologies that have been a part of the inter-parties review process, we see, and this is on slide 5, we see that electrical and mechanical cases are the vast majority of the cases of inter-parties review. And I'm wondering, Todd, if you can help kind of us understand kind of the varied technologies and how that might affect people's perspectives of inter-parties review, and whether we can see that changing in the future.
I think the proponents of this process, the proponents of the way it particularly it's turning out, tended to be in the electrical and computer arts area and the business methods area, though many of the business methods are going through the CBM process as opposed to the IPR process. And so I don't think it's, at this point, too much of a surprise. I think it tracks where a lot of litigation is. I think something like 80% of the cases, the IPRs, are filed in cases where there is active litigation, which actually begs the question that we may talk about later, by the way, which is, should we just allow anybody to file an IPR without any interest at all other than just trying to kill the patent? But that tracks pretty much, I think, where litigation is. Will it come around? Maybe. I think the piece that's still unknown in large part is what's the PGR part of this going to be. The patents that are subject to PGR have only recently come online. I think you have one. Is that right? Like 1 or 2, maybe?
Fewer than 10, for sure.
And if it tracks, for example, in Europe, I believe there's a much more significant part of the oppositions which are in the pharma area, and so you might see a rise there.
Todd, do you find clients are interested in the post-grant review proceeding more than, say, IPR, or are they just too soon to tell?
Too soon to tell. I think they will be, because again, PGR is more of a wide open process in terms of what you can use. However, it'll be interesting to see the reaction of the board. On ex parte appeals, the board is usually upholding the office significantly more than they have been on IPRs, and some would argue that's because the ex parte appeal judges see these as a lot closer. They're basically ratifying or not ratifying a very recent or very near-term examiner opinion, and that they, at that point, they're being much more like the office as a whole. Will that happen in PGR? We'll wait and see.
Judge Smith, I was wondering if you might be able to comment on the different technologies that the board has to address and how you've structured the board so that you can accommodate those different technologies.
Well, first let me say that that post-grant proceedings do comprise a full-time job for me, but I have another full-time job which involves our appeals. Well before there were post-grant proceedings, there were ex parte appeals. There are still ex parte appeals, and they come to us in the order of about 800 to 900 new cases per month. If all the post-grant proceedings went away tonight, the board would still be a very busy board, which is one of the reasons it continues to grow, to handle not only the post-grant load, but the ex parte appeal load. In fact, the current growth of the board turns out to have been a fortuitously timed thing, because it was in the process of growing to handle an enormous ex parte appeal backlog even before AIA hit. And we knew it was going to hit and we'd have to grow for that. And then what happened is not only did it hit, but whereas 500 cases were predicted to be filed in the third year, we had 1,494. A lot of work. Our post-grant filings do track very much our ex parte appeals filings in terms of technology layout. So the assignment of the work at the board is fairly uniform with respect to technologies, which is to say we don't require a different approach for the assignment technology-wise on the trial side in contrast to the appeal side. We did expect that the layout would be somewhat like it is. It somewhat tracks not only the activity in district court, but also the activity at the agency in terms of examination. So that was no surprise. We tried to keep our ears to the ground in terms of what's coming, and I think we have heard that entrants or participants in the overall ecosystem of the patent world on the biotech and chem side have been somewhat more reluctant, at least in the early going, to venture into the post-grant space, and that would in time change. Certainly we've seen more of those filings in the last year than we saw in the first 2 years. But there are a lot of other things at play in that arena as well, about which there has been a comment in recent times. I see that the General Counsel of Bio is in our audience, and he might have some thoughts as to, he may know how our pie chart is changing even before we do.
Yeah, thank you.
Now, but in fairness, you have the right to limit the number of IPRs that are filed by statute, yes?
That's I wouldn't, let me say, I think almost, which is to say I think the statute particularly limits the number of instituted proceedings, okay, which might be set by some mechanism. The statute is somewhat awkward with respect to that. Of course, you can't limit the number of proceedings instituted on a basis after the filing other than the merits of the case, at least not conveniently. And the statute doesn't preclude or grant the director through whose power institutions are made to limit the number of institutions. But does grant the director discretion with regard to the number of institutions. So in order to limit the number of institutions of trials, the director would have to somehow anticipate the rate of grant and limit the number of institutions, which is in the director's power to do. But essentially, the answer to your question is yes. But I don't want to just say yes to it, because then someone will point out that it wasn't really yes because there were these further aspects of complexity. So, in fairness to the record, I have burdened your ears with what I just said.
Judge Smith, do you think you're close to an area that you might have to invoke some of those processes, or are you fully staffed so that you can address the IPRs that are filing to date?
First, let me say, the views I express here are my own. They're not necessarily the views. Well, no, they're not. Maybe they're not even my views, but they're not the director's views either. My understanding is that at the current time, the undersecretary has no intention to limit the number of proceedings where trials are instituted solely based on the number which we are receiving.
Thank you. The next area that would be interesting to address is, in addition to adjudicating the validity of claims and getting clarity of the invention at the PTO, one of the other reasons people file IPRs is to pursue a stay at district court, and then, and this is slide 6 and slide 7, slide 7, we move to another reason why people file IPRs, perhaps, is to kind of create the conditions for a suitable settlement. And Kim had mentioned that earlier. And I'm wondering if Kim might be able to weigh those for us. If we look at the three things that have been identified, one is the adjudication of validity with a kind of a subset of clarity on the invention, stays of a district court litigation, and the settlement of an IPR. Is there a particular weight of strategy or a weight of how you as a practitioner would be pursuing each of those, and what's your expectations moving into a proceeding?
Sure, I'll take those one at a time. So on the stay side, we have some numbers up there, I think. And you can see that there seems to be some impact by the IPR process on when courts are staying. And the question is, what does each jurisdiction do with respect to stays? Because even though we have these numbers up here kind of addressing stays globally, if you're in, say, East Texas versus the Northern District of California, you're going to see very different stay results. So you have to kind of take that into the mix when you're coming up with your strategy. Generally, I think it's good to try and seek a stay of your underlying district court litigation for a number of reasons, not the least of which is cost. These are both very expensive proceedings, and so if you can get some clarity through your IPR process to either minimize what's going to be going forward in the district court litigation, or even render the district court litigation unnecessary through a successful IPR process or settlement, then that's a good thing. And you don't want to be incurring the burden of the cost of that litigation concurrently with the IPR process. And I think most judges understand that. You may be more at risk of doing parallel proceedings in some districts, again, like Texas. Though even there, if you have institution on all claims, I think you'll have a judge that will be pretty reasonable in granting a stay. So stays are an important part of the IPR strategy because it's expensive to go after both of these.
One thing we're going to have to wait and see a little bit more on is to the point that was made about jurisdiction. Some have suggested that it is aggravating the issue of venue choice and forum shopping if the Eastern District of Texas is going to have a very low stay rate as compared to others they have. Query whether that doesn't mean we're going to see more filings in the Eastern District of Texas for that purpose, so that the patentee's patent is not as threatened, I guess, by the IPR process.
And it does create. I mean, anytime you modify the system in one area, it always tends to try to reach an equilibrium, and that is a result.
Now, the AIA, we struggled mightily for the 5 or 6 years of the debate about the AIA to come up with a venue provision that everybody could live with that would try to avoid that so-called problem in the Eastern District. Nobody could ever come up with one that there was general agreement on.
Yeah. Todd, when you mentioned venue selection, what about settlement? Like when the AIA was being debated and kind of considered throughout the kind of the development process, was settlement a part of the consideration, or is that kind of almost a happy afterthought of an event?
Well, I think to the extent it was considered, it was primarily considered, I think, in the context of settling the litigation, and that the IPR would decide an issue that then would be used to settle litigation. The question of settlements of the IPR, which is a separate question, was probably not quite as widely discussed. Most of these statistics, I think, are these not relative to the litigation? No, this is relative to the IPRs themselves. Another issue that's arisen is that the board has taken the position that even if the parties do settle, the board has the authority somehow to continue the IPR. And so they have continued it in some cases, putting more patents at risk, I guess you'd say. And the question of whether they have there are a lot of questions about authority under the AIA that will be decided presumably by the CAFC at some point, and maybe even the Supreme Court, and this is on that long list.
you know,
Well,
one of the, go on.
a couple of quick thoughts. One, I think what we're seeing in most instances is that the settlements are not IPR specific or CBM specific. They're more global settlements between the parties and usually sweep in the district court litigation. That wouldn't be surprising, really, because as we've been discussing, you have sometimes an 80% overlap, or about an 80% overlap of IPR or CBM with an ongoing lawsuit. In fact, CBM, of course, the suit was required, so you necessarily have the overlap. I don't think we've seen any settlements which are only of the IPR or CBM except where there is no district court litigation. So they're being used more comprehensively. With regard to the board proceeding with a matter even after settlement, I don't think that's something the board dreamed up. I think the statute specifically points out the opportunity to do that, and I would say even the requirement where the board sees that there's an important public interest issue which has been raised in the proceeding and needs resolution even in the absence of the parties, and we're trying not to ignore the obligation that the statute puts on us with regard to that. Also, I would say, and this is not so much a system comment as to whether or not stays are appropriate or working, but it's a more myopic PTAB view with regard to a very important stay issue. At the board, we believe it to be our obligation to adhere to the time requirements of the statute. And so far, in 3 years, and even though we had 3 times as many filings in 2014 as was predicted, the board did not miss one deadline, which is to say the period of time granted for deciding whether or not to institute the proceeding, and then the later timeline when a trial is instituted to be through to final written decision in 365 days. We have yet to miss those deadlines even once. This is important to us because we think, again, whether stays are correct or not, whether there's some variation in how they are granted by the various courts, we always want the courts to be able to say with regard to the timeline, that is how quickly the PTAB proceeding will move if the district court action is stayed, that there is almost no opportunity to give thought to the PTAB not completing its statutory duty in the statutory time.
I think that, go ahead, sorry.
It certainly makes our motions more compelling when we ask for a stay, to have that adherence to the timeline be so rigorously followed.
I think the office should be congratulated on that, and you in particular should be congratulated on maintaining that, because the statute does call for that. It does continue the debate, however, that was there before and the statute was adopted, that is 1 year enough time given the importance of some of the patents and the complexity of some of the issues. And so another part of this discussion this morning is going to be are the procedures that lead to that speed questionable under due process grounds and others? Are you getting a fair hearing? Are you allowed to get your amendments in? Are you able to get secondary considerations considered appropriately, et cetera, because of the adherence to that timeline? It's also why I raised the suggestion of the opportunity to limit the number of post-grant proceedings in order to give more thorough consideration to a smaller number.
That's great. Thank you. And I think that part of moving to the process of IPRs, and we're going to slide 8 right now, looking at the different rules that are a part of the process to kind of institute and to proceed with in a party's review. And I think that I wanted to hear from each of the panelists on kind of how the rules are, kind of their experience of the rules. Like, are there particular gaps or timing or substance? And Judge Smith, if perhaps you could start the comments with the status of the rules that, or the comments that were requested and were due last fall, and I would imagine the Patent Office has been reviewing them, and I was wondering if you might be able to provide a status of those, and then we can talk about different aspects of the rules.
Sure. We're doing our best to turn around rules changes as quickly as we can. I was surprised when I came to the government to learn just how much is involved in rulemaking and how many people's eyes have been on the proposed change before a change can be made. So it takes some time. I'm also amazed at how when one is taking the whole set of information, all the comments about various proposals, one often will hear, this is great, please don't ever change this. And then in the very next comment read, you idiots, why did you ever think to do the thing that the other person thinks is the thing that absolutely shouldn't change? So there's quite a bit of that to work with. There has been a fair amount of uniformity with regards to the desire for certain change. For example, one of the things about these proceedings is that they permit the filing of motions to amend by patent owners, and there's been fairly uniform complaint that the number of pages allowed for that is insufficient. While I am not permitted to say, because it's not done until it's done, that change will come about, I think I can say that change will come about. And in fact, that one may come about early. For careful watchers, it's actually come about already, because the board is not declining to grant motions for enlargement of pages for motions to amend. So anyone wishing more pages and hoping for the rules changes can hope for more pages and see them even before the rules changes. But that's just one example of a rule change likely to be in the package of rule changes. There are certain of them that will probably come about sooner, and certain of them that will come about later because they're more complex and require more public vetting before we can make them. Of course, meanwhile, as we're considering rules changes, there's also quite a bit of legislative activity ongoing, some of which may move at a pace that causes that legislation to interact with rules changes we are endeavoring to make. That introduces a certain wild card in terms of timing. Setting that aside, though, the plan of the agency is to make certain simple changes fairly soon, including page changes for motions to amend, and then later to make some more changes that have to do with things like discovery and putting in new evidence prior to the institution of trial. Let me just say about the page limits with motions to amend, and I offer this comment just to illuminate some of the decision-making process. The board did not attempt early on to limit motion to amend briefing just arbitrarily. In fact, the page limit that drives that came about because a motion to amend is a motion, and there was a general page limit on motions, which page limit has not been complained about pretty much by anybody. Just so happens that this is one motion where more pages seemingly are appropriate, and so the evolution to add the number of pages is a natural one, but it's not against the arbitrariness of limiting motions to amend. It's that it just happened to be another motion which we did not anticipate would need separate treatment in terms of allowing for the briefing on it.
Yeah, Todd.
Just on the rules, a little history I think is valuable here as well. When the rule package was being developed, the director at the time, Director Kapos, came to the three major bar organizations. I was the executive director of the IPLA, the IPO, and the IPL section, and asked us to provide two experts so it was a so-called panel of experts, or the gang of six, depending on what you wanted to call it, to develop a full set of rules that we thought was in the best interest of the system, which we did. It was a very elaborate process we went through. Getting the 3 groups to work together was interesting.
96 pages from what I read.
There you go. Those were presented at the time, as we said, at the request of the director, and none of them were adopted. After the rule package was published, as you know, you go through the next step of the rulemaking, which is to comment and propose other changes. We came back and proposed the same set again with even tougher reasons why they were better. None of them were adopted. And so there's a concern, I think, in some quarters that, at least initially, the set of rules that was adopted was heavily informed by the judges who were there at the time, many of whom came with the experience of interference practice. And so you see a lot more attention devoted to the procedural aspects, a lot more attention devoted to motions for motions and that sort of thing, as the judge was suggesting. The interpretation that the statute doesn't give you a right to amend; it gives you a right to file a motion to amend. That sort of sense. And so that's why I think you're still seeing a lot of the comments that you are seeing about what are, I think, perceived as procedural inequities, and the system does favor, at the moment, is biased towards the procedural.
What would be 2 rule changes that you'd suggest at this stage?
That I'd suggest?
Yeah.
Well, there's I should also point out, as the chief suggested, there is a statutory the concerns about the original statute that we're talking about now is to cure so-called litigation abuses by trolls. Others have now said, hey, maybe we should look at PTAB abuses, characterizing them, unfortunately, that way. And so you're seeing things like the Strong Act that Senator Coons introduced. In that act, let me just say that here's some of the suggestions that were made and that have been discussed. One is the widely discussed issue of moving the standard of review of claim construction from broadest reasonable interpretation, the traditional PTO standard, to the so-called Phillips standard of claim construction that district court judges use, which should presumably tighten up the claim construction, and we'll probably debate that in a minute. Making the right to amend clearer was one that was suggested. Reinstituting or instituting for the first time the presumption of validity into the process, either at the get-go, as patents are considered now in litigation, or maybe phasing it in over time, like we do with trademarks. The longer the patent has existed, at some point the presumption comes in, and might, among other things, encourage earlier filing. Separate the the initiator decision from the decision-making function. There's actually a lawsuit, an appeal now filed by Ethicon, a J&J subsidiary, which says that the statute needs to be read in that exact way, that because the statute says the director can delegate the initiation process for an IPR as they choose to people that they have appointed. And if you remember, this is kind of complicated, but the Supreme Court has ruled the director cannot appoint judges any longer. Only the Secretary of Commerce can appoint them, and therefore it is wrong to be delegating that authority to initiate to the board, that then a separate panel has to be set up to do that. Also for a goal that the panel sometimes gets so invested in their initial decision that they're loath to overturn it later. Also that perhaps to have require some relationship, financial relationship presumably, to the patent holder. Litigation would be a good example, or a threat, as we would for the DJ action, that you shouldn't allow patents to just be attacked willy-nilly by third parties. Others have pointed out that it's in the best interest of the system, and that you should be able to do that. But that's another change that might be helpful.
Can I offer just three additional comments?
Yeah,
One,
yeah.
with regard to the development of the rules, there were many influences, and I think certainly there were judges who participated in the development of the rules. The public did in large part as well. We received 250 comments which occupied 1,000 single-spaced pages, all of which were carefully reviewed by the committee that we had working on the rules, and all of which comments were responded to in our drafting of the rules. We also had input from district court judges who assisted us with, among other things, considering whether the discovery regime proposed by the committee of 6 experts was practical and would make it possible to complete discovery in the time allotted under the statute. So there were many influences. Let me also speak to the difference between, for example, motions to amend and merely being to amend without motion. This is not something that was developed in the rules. It's actually what the statute requires. And lastly, just this point, I think it is a misperception that judges are somehow judges who participate in decisions to institute trials are somehow invested in decisions in a way that makes them want the final written decision in the trial to come out the way the institution decision did. Why? The judges have no vested interest, have no difficulty with reaching a different conclusion at the end than at the beginning. I think if one actually reads the decisions of the board, one will see in perhaps an overstated manner judges saying, this is where we come out given how the record reads at the current time. We don't mind at all if the record reads differently by the time this is over and we reach a different decision. I wish I had $1 for every phrase like that in the decisions of the board, because the judges do not view it as a matter of prideful hurt if the decision as it appears in the final written decision is different than the decision in the decision to institute. Now, I don't think any of that detracts from the point Mr. Dickinson is making. There may well be more of a distinction between, let me not say distinction. The statute may intend a more clear divide between the execution on the director side with regard to whether or not to institute a proceeding, as contrasted with the adjudication side, which is the function of the board and may not be interfered with by the director or the president. If that is the conclusion and a separation comes about, then, as I've indicated in other remarks, the board will do the best with the duties that it has been assigned in the manner it is told to execute those duties.
If I could make a point on the broadest reasonable interpretation comment. There's been a lot of hand-wringing over broadest reasonable interpretation in particular, because it seems like there's been a somewhat limited ability to get a motion to amend granted. But I think you need to take a bigger look at the bigger picture. The PTO has been using this standard for over 100 years. And you're passing legislation and interpreting, how to interpret the claims with that as background. And coming at it from a litigation perspective, what we see over and over again in a lot of these cases is you have a plaintiff who is construing the claims one way for invalidity position and another way for the infringement position. It's the nose of wax quote. And maybe I don't know if we have law students in the audience, but there's a great Supreme Court case from 1886 that refers to a nose of wax being twisted and turned in all directions, and I guess it's something from Victorian era theater. But anyways, they always talk about claim construction as being an exercise in twisting and turning the claims to basically read them on whatever it is you need the claim to read on, or avoid reading on, depending on whether you're in the infringement context or the validity context. So if you're going to have these separate proceedings in the PTO where you're really vetting what this property right is that the patent holder has, I think the broadest reasonable construction is entirely appropriate, because you're testing the limits of that claim, and you're getting people to understand exactly what the boundaries are in view of the prior art. Otherwise, if you were allowed to have an interpretation here, you might see it. You might see it morph once you get to the district court case to be more read on the accused product. So I think it's a good thing.
A couple of quick comments. One is that the usual defense, I think, that's given for the using broadest reasonable interpretation is that there is an opportunity to amend. And why this has now become an issue is in no small part due to the fact that there have been so few amendments allowed. I think the office they put out a press release when they did their first amendment. They were so proud of it. Now, with 1,000 cases come through, something like that, there have been 2 amendments, one of those to a government case, something like that. So, James is going to say, because we're not examiners, except when we're doing ex parte appeals, when we do search and examination, we're not examiners, now we're judges on this side of the ledger. Therefore, we have to take your amendment as you give it to us, and we can't do anything to try to change it. And
actually, that's not what I'm going to say.
All right.
You can wait to hear what I'm going to say, or
no, that's all right. But let me point out that on Barsley's interpretation too, it's sort of as Director Capos said the other day in New York at a conference, it's a close call. It's not catechism. It is you just got to come down one way or the other. The usual defense is that if you're going to you shouldn't have district court litigation and the office's interpretation at variance, and that they should adopt the same standard. I'd also point out that in the last Congress, when this was debated thoroughly, the House voted to shift to the Phillips standard. The Senate committee would have voted because the draft bill that was before them had that in it. I think Congress is on board with shifting the standard at this point.
One approach is to shift the standard. In fact, there are at least a couple standards one could shift. One could shift from preponderance to clear and convincing on the ultimate question. One could shift from broadest reasonable interpretation to a Phillips district court-like construction. I think in terms of overall logic and consistency, if one shifts from broadest reasonable to the same standard used in district court, then the right to file a motion to amend, which is to say a opportunity to amend, ought to go away because that doesn't exist in district court, and then you have true consistency as between district court and PTAB proceedings. With regard to whether or not motions to amend are granted, let me ask this. How many of you here have read at least a couple of motion to amend decisions by the board? How many of you have read 10 or more? How many of you have read them all? Every one of them, to determine exactly why it is the motion was not granted, reviewed the record?
I have not. Perhaps
I'm somewhat alone in this. I don't think I've read them necessarily all, but close to all. The difficulty with the grant of the motions to amend, one has a very different picture of after you read the motions to amend. Oftentimes, they fail because, for example, the new language has no counterpart in the specification and no support. Sometimes they fail because even though there is support in the specification, the amendment doesn't even overcome the art that was put forward by the petitioner and is the subject of the proceeding. There are all sorts of reasons why the motions are failing. Another one is that uniformly patent owners are declining to say this. Based on the art I know of, I think these claims are patentable. Now, I can see why there would be the hesitation on the part of the patent owners to make a statement as to patentability. It might be held against them. But those same patent owners want the board to make a statement of patentability by, in fact, granting the amended claims. Please tell me, after you have read the decisions and after you see the rationale of the denial of the motions, what your view is with respect to this subject.
As the former general counsel for the office said at a conference about a year and a half ago, if we knew they were going to interpret the rules this way, we wouldn't have written them that way.
So when we look at the motions to amend and we require a declaration from an expert saying, yes, we think this is patentable, Judge Smith, like what additional things would you think that a patent owner should bring into a declaration or a motion to amend, a declaration supporting a motion to amend, or the motion to amend itself that can be more persuasive to the board?
Well, I'm not sure. I think you may have made a statement that goes a little beyond the board's requirement. I don't think there's any specific requirement that an expert make a particular statement. That is, there are other ways in which the representation as to patentability can come into the record. Fundamentally, and maybe we're wrong on this, maybe we shouldn't ask the patent owners to show support in the claim. Maybe we shouldn't ask the patent owners to say, we think it's patentable, but we're not willing to say it, or rather, maybe we shouldn't ask them to say that they think their claims as amended are patentable. Maybe that's a stretch.
Well, again, practitioners are not likely to, I don't think, include amendments which are not going to be later upheld in court. I mean, as we said, most of this is in litigation. So if you amend the claims, theoretically or practically, are you not trying to put the case in better shape for both the litigation as well as the IPR? This is why I think you asked about changes that I would recommend. One of my favorites are pet changes, because we are trying to improve quality, not just kill patents, would be to, once an initiation occurs, be able to grant a stay of that initiation to the patent holder and allow the patent holder to go back into either reissue or possibly re-exam, but maybe reissue and go back into the examining part of the office and clean up the case relative to prior art that may have been cited, if it's possible. Maybe it's not possible, but let them go back through reissue, presumably narrowing their claims, and then let the process go forward from that point of view. Stay the 1 year period too in that regard, so that it doesn't count against the statistics.
I'm wondering if there are any questions from the audience. We're nearing the end of our time, and I want to do two things. One, any questions from the audience I'd like to invite, and then second, I want to give each panelist an opportunity to spend a few moments with any closing thoughts that you may have regarding the post-grant proceeding, success, anything we've talked about during our panel today.
It's amazing how quickly the time flies when we're talking about these things.
So are there any questions? Sure, Jay.
Why does the USP2 have so many different post-grant proceedings? Can't there be some kind of consolidation? It's a dog's breakfast of confusing acronyms and procedures. Can't we do better than this?
There are 8, yes. Well, for good or bad, the statute requires it. And
do we have a congressman in the audience to whom we can direct the question? Yes, our lunchtime speaker should be able to address that subject. I'm not. Dog soup of
dog's breakfast.
Dog's breakfast. I will confess having not heard that one before.
Well, almost all of it rests, I think, on the belief that the office is in a better place with expertise to allow for the review of patents by the experts in the office after they've issued, that doesn't necessarily. I think, and also there's some dissatisfaction with earlier processes, like inter-parties re-exam, another re-exam, that they only went so far and only so much evidence and estoppel applied. You didn't want to always apply. A lot of different reasons why there's a different procedures. Whether that's a good thing or not, that's a good question.
The mere passage of time will itself provide greater simplicity. Inter partes re-exams are going away. We see a big bubble of them because many were filed before one no longer could file them, but in time there will be no more of them. So that's one point. Covered business method review, that had a sunset provision in it, so with the passage of time that also will go away, and largely those proceedings will be subsumed within PGR. And then I think fundamentally the structure leaves you 3 things. As Mr. Dickinson was saying, a first window proceeding in the first 9 months, PGR, that allows you to attack broadly while the grant is new. And then a second window IPR, the length of the life of the patent, where the challenges are more narrow, so the title might be more quiet. That's really fundamentally the 2 surviving and persistent aspects of AIA post-grant, assuming no further changes to the overall scheme. Separately at the office are these other proceedings that will not go away, ex parte re-exam and reissue, which are very long in the tooth, reissue especially, and which have separate and separately legitimate bases for existing. Again, to Mr. Dickinson's comments, re-examination or reissue provides the opportunity to vet a patent and claims and to make amendments in a way that's not possible in the post-grant proceedings because there is no examination in the post-grant proceedings. So I think, short answer to your question, in my view, the number of acronyms will go away in time anyway, and then you're left with a fundamental scheme that maybe is fairly rational in its overall composition.
And we have supplemental examination too, but that seems not to be used. I think a key question is going to be, will PGR be used relative to IPR? It was put in there, again, people saying the office doesn't have enough input at the examination stage. We need, as a third party, we need to be able to bring that to it. We can't do it other than through what is perceived as a narrow opportunity to submit third-party prior art during the examination phase. So we need to be able to do it as we come out of it right away. Query whether those people who've made that argument are going to be filing PGRs, or are they going to, as happens with third-party submissions, are they going to wait and not give the office their best evidence early on and wait to get into litigation before they bring these forward in an IPR when hopefully they should be doing it very early on in a PGR? We'll wait and see.
And I think this will be a test of part of the fundamental thinking prior to having a statute, again, going back to the National Science Foundation study. If the opposition model really has the kind of viability that it was presumed to have when we headed down this path of reform, then we should see opposition-like interest in PGR proceedings, right? Because of course oppositions are very heavily used in Europe. The players in any given industry typically are strategizing to make sure that that first window where the challenge can be made is not allowed to pass without taking advantage of the opportunity to move out of the way patents which are viewed as having been improvidently granted. Will the U.S. duplicate that? Time will tell.
Would the office support a kind of a rule that said something like, if the party was aware of the art and could have filed a PGR and didn't for some reason, that the art is not available to them in a later IPR?
We'll pose that to the people who get to make those decisions.
Well, thank you. And maybe last word, Kim, and then Todd, and then Chief Judge will give you the final opportunity to share with us any observations.
Sure. So just a closing comment to any practitioners out there who are trying to weigh whether or not to seek an IPR and are concerned about, say, things like estoppel. I would say if you have something like a two-reference obviousness argument that you're considering, then it's solid technically, take it to the PTAB. You have a very sophisticated, savvy panel there who can understand that technology, and they understand that the examiners are under a heavy workload and have some constraints in what they can look at when they're issuing the patent in the first instance. That's compared to a jury in Texas or wherever. So even though there is estoppel, it's something that you shouldn't be too concerned about. And again, there's also the broadest reasonable interpretation that you get at the PTAB. You get your preponderance of the evidence burden instead of clear and convincing, and you don't have the presumption of validity. So if you're weighing that and are concerned about giving up your validity case in the district court, don't be. It's a good proceeding, and it's been very, I think, productive in getting people to where they need to be in understanding what the values of the patents are.
Thank you, Todd.
I think and I guess my role here today in part was to be the Greek chorus or the critiquer. I think there's over the way the system is playing out at the moment, I think it's very valuable the office has undertaken and will undertake this new rules review that they promised from the beginning they would, and I think we're pleased to see that. I hope they take a lot of these criticisms to heart, because there is, I think, a very strong sense, perhaps mainly in the bar, but I think in certain technologies as well, that the system is tilted too far in one way, that the office does interpret the statutes far too broadly. We didn't even talk about, for example, CBMs and how they're interpreting financial services. If you've charged for anything, apparently that causes you to be a financial services patent. And the effect of the CFC on all this. There is, I think, actually a huge number of cases. I think this month alone, it was pointed out on a panel the other day, 25 cases of the 75 the CFC will hear this month are coming directly from the office. So the CFC is going to decide a lot of this but have a huge workload. At the same time, I think the office is intervening in something like 20 of those cases on the rules themselves. So we're still in fairly early days in terms of how this process plays forward. I think in terms of certain goals, as I said, the office should be commended. Contrary to everybody's, frankly, almost everybody's belief, they have held that 1 year time frame, and I think that's a great success that they've enjoyed. I think that by loosening up things a little bit, page limits is a nice start, but I think allowing for more amendments and allowing cases to be put into better condition, I think was the intent of the statute all along. Giving greater weight to the other things in litigation, primarily, or for example, rather, secondary considerations. There was a whole panel, or a whole review just the other day on the fact that the office doesn't seem to be giving nearly as much weight to commercial success, for example, or long-felt need as it does to the technicalities of 102 and 103. Whether they're going too broad in their interpretation of what can be used in the PGR, we're starting to see some cases where they're actually using 112 as a rejection, which they're not authorized to do under the statute, because they found a piece of prior art which suggests that there's a 112 problem with the claims. All of that, I think, over time will get smoothed out. So I'm optimistic about where the system will head. I think that the best news is the office is sticking to its mandate, and that it's also, I think, providing the opportunity for the public to give honest and fair criticism, which hopefully will be reviewed and adopted where necessary.
A few things very, very quickly. Poor PTAB. The Federal Circuit says secondary considerations show nexus. Don't just say there's been success of the claimed invention. Show that, one, the product you're saying sold successfully incorporates the claims, and that it's not just marketing which sold the product. We ask for that evidence, we don't get it, there's no nexus, and we're seen as being hyper-technical because we followed what the Federal Circuit would require if the case were to go up on appeal. Shame on us. Financial services, incidental to financial activity in a way referenced in the patent. Not a definition we dreamed up, came to us from Congress. Stated clearly in the legislative history.
One member of Congress, I believe.
We adopted in the rules, and then were accused of dreaming the stuff up and being overly broad in our reach. Show us a different definition from the people who wrote the statute, and maybe we use it. Let me say this generally, though. Because these are, to some extent, the small points within a larger scheme. The Patent Trial and Appeal Board has no vested interest in the outcome one way or another. Our only goal is to serve Lady Justice. We get no more pay, no less pay if one party wins or the other party wins. We're just trying to do the job as properly as we can. any assertion that we're trying to move the rules one way or another so as to help one set of parties as opposed to another set of parties, please hear any such suggestions with total and complete skepticism. The last thing I want to say, because I promised I would ever do it if I were in a Georgetown building, is to say, here we go, Hoyas, here we go.
Well, thank you. And please join me in thanking the panelists for their comments, their time, and their insights.
Okay, let's go and pick up the pace here and get our second panel started again. My name is Jay Thomas from Georgetown Law, and we're going to start now our second panel, which is on multinational patent enforcement. Now, I have three distinguished panelists. To my right, we have Trevor Cook, who is a solicitor admitted in England and Wales, so he's my friend, but not my learned friend. You get that joke? And he's been a fellow traveler for many years and is a prolific author. I think, what is the title of your book? You have the modestly titled book among many on pharmaceuticals, right? It's
Pharmaceuticals, biotechnology, and the law.
Pharmaceuticals, biotechnology, and the law. So I think we're competing authors on that. So I'm not sure, in the
No,
pharma space.
I'm EU only.
That's right. That sounds good. But Trevor is a prolific author. He was a partner at Bird & Bird in London for many years, and had at long last has wised up and immigrated to the United States, where he's now with Wilmer Hale. So thanks for upping your game, and I'm glad you're on this side of the pond so we'll have more chances to interact in the future. To Trevor's right is Jamie Lynch. Jamie has been running easily the most significant global patent litigation in the world in the pharma and life sciences space over the last 3 years. He has been enlisted me as part of that at his position at Gilead. He's a charming fellow, though he does have the habit of scheduling trials in cities north of the Arctic Circle during the dead of winter. I mean, really, other than that, he has many fine qualities. And actually, when we wanted to put together this panel on international patent enforcement, I really wanted to have Jamie, because he's been doing it now, and it's been terrific. Formerly, he was a partner in Chicago at the Mayer Brown firm, and has been at Gilead again. I think he's had a little bit more of work than perhaps he anticipated with all of this.
Indeed. Thank you, Jay. Thank you, Jay.
No, it's great to have you here. Thanks a lot for coming. And to my all the way down at the end is Mark Selwyn, a partner at the Wilmer Hale firm and one of our leaders in international patent strategy. Now, my students who are taking my course this semester know that we have, as patent lawyers, we have a seeming comfort of substantive patent law often. So we have basic things like novelty or inventive step. It gives us sort of a false familiarity with the patent systems of other jurisdictions. But most of the basic patent granting doctrines are pretty similar around the world. And they may differ in their implementation, but at least the terminology is much the same. Things obviously couldn't be different when it comes to patent office procedures and particularly litigation. And so you're beset by a dizzying array of procedures, courtroom culture. Jamie, over the last year, has been dealing not just with law professor witnesses, but with Scandinavian lawyers and patent office procedures and Southern judges and all just a cast of characters that would boggle the mind. Even when I teach my domestic patent law course, I make sure to do a lot of international aspects to it, because pitting patents in just one jurisdiction no longer suffices. Okay, it's not going to protect entrepreneurial interests. So I think a panel like this is very timely and important. Now, I'm sitting here, but of course the laptop is here, so I'm going to play the crazy seat game, I think, with each of my panelists. So I will not assume their identities, but I will sit behind their tent card momentarily. Shall we begin with our first panel? May I take your chair? Let's try it. We're a collegial group here at Georgetown, so try it out.
Good morning. We're talking today about significant changes in IP litigation and IP procedure. One of the most significant changes that has occurred and continued to occur is with respect to global IP litigation. We've seen increasingly in the last 3 to 5 years litigation not just focused in the US, but with companion cases, counterpart cases overseas. This is a trend that's here to stay, and we as practitioners have to arm ourselves with knowledge of the arsenal that's available in other jurisdictions as we advise our clients. I'd like to suggest that there are at least 3 reasons for this change of the trend towards globalization of IP litigation. The first is the increasing sophistication of courts and practitioners worldwide, including in smaller and emerging markets. The courts are looking to one another globally, being educated by one another globally, and there's an increasing sophistication worldwide. Second reason is the world is becoming a smaller place with global supply and distribution chains, markets outside the U.S. taking on greater prominence, and the proliferation of standards. We are seeing that as a force that is causing an increasing amount of global IP litigation. And third, changes in U.S. IP law and IP litigation have in certain ways made the U.S. a less attractive forum and started to cast our eyes overseas for other alternative forums to be defending intellectual property. For example, in the U.S. in recent years, there's greater difficulty in obtaining an injunction. There's increasingly rigorous requirements to prove damages. There's Alice in the impact that that decision is having on the number of filings and the uncertainty that it has created. And as we saw from the last panel, there's the IPR practice and the fundamental change that that has brought, and the increasing number of cases that are stayed as a result of the Alice decision. So I think these 3 factors taken together are in large part the reason why we're going to see an increasing amount of litigation outside the U.S. By U.S. companies and otherwise. I want to briefly touch upon some of the considerations that go into formulating a global IP litigation strategy. Jamie's going to talk about this at greater length, and I'm going to touch upon them really from the perspective of outside counsel. Jamie's going to talk about it more from the perspective of in-house counsel, and discuss some of the experience that he has had in that respect. First consideration, speed. There are a number of very significant foreign jurisdictions where you will get to judgment much more rapidly than in the U.S. And, of course, an early favorable judgment, even if it occurs in a smaller market, can create substantial pressure towards resolution of a matter. Second issue, cost. We're talking today about a lot of things that have changed in IP litigation. One thing that has not changed in a material way in the last 5 or 10 years is the cost of U.S. litigation. A lot of time has been spent to try to rein in the cost, rein in the amount of discovery, e-discovery, and so forth. But I think most practitioners will tell you that the cost really has not changed in a significant way. The fact of the matter is that litigating abroad in a number of very significant jurisdictions can be much less expensive than litigating in the U.S. And one needs to consider what bang you get for your buck. And it may be that in certain jurisdictions you will get a greater bang than if you litigate a similar patent within the U.S. Outside the U.S., depending on what jurisdiction, you may have little, you may have no discovery, which obviously has a significant impact and reduction on the costs. Likewise, depending on jurisdiction, you may not have the types of lengthy trials that we could have in the U.S. You can get to a result in a much quicker, more efficient manner. Next consideration is to formulate the global IP litigation strategy. What are the key jurisdictions on the supply chain, both for your company and for your competitor's company? Where are the choke points in your manufacturing chain, in your distribution chain, and likewise, where are your competitors? We need to consider jurisdictions that may have relatively small markets, but can be very significant in the distribution chain or in the manufacturing chain. The Netherlands is a very good example of that. Population of the Netherlands is about 18 million. For most companies, not a significant market, but for many companies, a very significant country in terms of distribution within Europe. The Netherlands is a place that has a very sophisticated patent bar and a very experienced and sophisticated group of patent judges and is very efficient and quick in its deliberation and resolution of IP matters. Discovery. So as you formulate your litigation strategy, think about what countries you would want to bring litigation, and one consideration is what discovery would be available in that jurisdiction. In the U.S., of course, we can anticipate when we file cases, we'll be able to obtain the discovery we need to provide greater detail and proof of the allegations in the complaint. In many jurisdictions, that is not available to you, at least within that particular jurisdiction. We'll talk a little bit later about a mechanism that exists in the U.S. to provide evidence discovery that can be used abroad. But in many jurisdictions, there is not the type of discovery that we have in the U.S., and that constraint has to factor into the thinking about where to bring a particular case. Confidentiality. So in the U.S., of course, we spend a great deal of time negotiating protective orders, litigating protective orders, because given the amount of discovery we have and the very public nature of litigation in the U.S., companies obviously are concerned about disclosure of their confidential information. In many jurisdictions outside the U.S., there is not the same type of procedure. In some jurisdictions, presumptively, everything is public. Presumptively, everything will be able to be viewed by the other side and its employees. So one needs to consider what avenues are available in those jurisdictions that might be attractive for litigation to protect one's confidential information, and that can factor into the choice of what jurisdiction to consider for suit. Injunctive relief. So in the U.S., of course, over the last 3 to 5 years, the availability of injunctive relief has changed because of change in the case law. Outside the U.S., in virtually all jurisdictions, there's no such thing as eBay or eBay factors, and in most jurisdictions, injunctions follow a finding of infringement. So the availability of different remedies outside the U.S. can make litigating outside the U.S. much more attractive because remedies are available there that are not available there. Similarly, there's the availability outside the U.S. of preliminary injunctive relief in many places that is not available in the U.S. There's also the availability in some jurisdictions outside the U.S. of getting that injunctive relief on an ex parte basis, which creates opportunities if you're a plaintiff, and on the defensive side, one needs to consider how to prepare for that and possibly blunt it. On this issue of injunctive relief on a preliminary basis, some jurisdictions, the Netherlands is an example, Germany is another example, do allow you to file what are known as protective briefs. If you anticipate the possibility of litigation by a competitor, for example, you're permitted to put a brief on file that essentially says to the court, if litigation is filed against me, I want an opportunity to be heard before you make your ruling. But of course, that requires a fair amount of advanced thinking and advanced planning about what actions might be brought and on what paths. But as we think about the market globally and litigation globally, that's one of the things that companies that are global in nature need to be thinking about as we go forward. Another significant difference between litigation in the U.S. and litigation outside the U.S. is the nature of trials. In some jurisdictions, there will be essentially no trial as we think of a trial in the U.S. Trials resemble much more like an oral hearing that we would have in the U.S. than anything where there's a presentation of witnesses and so forth. In other jurisdictions, Australia is an example, trials can be quite lengthy. So one needs to consider, as you formulate your global litigation strategy, how it's going to play out and how the evidence is going to be ultimately presented. And then a final consideration I would just note is the possibility outside the U.S. of customs actions. For example, in Korea, in China, in other major markets. It's a non-judicial avenue for enforcement of IP that one needs to consider both on an offensive basis and thinking about on a defensive basis how you would handle a customs action were it to be brought against your company or your client. Final thing I'll mention is a vehicle that is available in the U.S. to obtain discovery that could be used abroad, which is 28 U.S.C. 1782. As I was preparing for today's talk, I did a search to try to determine how many times in the last year this particular procedure had been used in patent cases to obtain discovery for cases outside the U.S. And I was surprised by how few times it was used in the last year. And historically, last year, there were about 50 applications in the U.S. in patent cases under the section for subpoena to obtain evidence for discovery for use abroad. And it surprised me because this is potentially such a powerful vehicle for obtaining discovery for cases outside the U.S. The statute allows you to obtain either testimony, such as in the form of a deposition, or documents that can be used in a foreign proceeding. And the requirements under the statute are fairly modest. You need to seek discovery in a district where the person resides. You need to be seeking the discovery for use in a foreign tribunal. And the application needs to be made either by the foreign tribunal or by any interested person. And the cases have interpreted any interested person to be a litigant. So you can go into a court in the U.S., you can seek discovery that can then be ported abroad, and the application itself to the U.S. court is fairly simple. When one looks at the applications that are filed in cases, it tends to be a 5, 10, 15-page application accompanied by a proposed subpoena. And the evidence that is obtained can then be used in many jurisdictions around the world. So that has to be part of the thinking as we plan for the future and as we think about how we advise our clients on local litigation strategies. And with that,
So Trevor, would you like to take the driver's seat to the left?
Okay,
we'll,
fine.
We'll all get up and do our maneuver here.
We'll swap
But
around.
Jamie, you can stay. That's okay. You can take one too.
Okay. Right. Well, thanks very much for the invitation to participate in this seminar. As some of you may know, things are about to change in Europe, and we have this promised or threatened new tribunal, Unified Patent Court, which has been established under an agreement signed by 25 EU member states. It is, according to the official words, meant to be starting sometime this year, but much more likely is 2016, or possibly, realistically, considering the fact that this whole structure has to be set up from the ground floor up, it'll start in 2017. And for the first 7 years of that, which can be extended to 14 years, we're going to have a transitional regime whereby the litigation can take place either in national courts or in this new tribunal, subject to various opt-out provisions. So this introduces an additional layer of complexity to the structure in Europe in the short term. It offers new opportunities, and I'll talk about some of those as well. And it will apply to existing European patents unless they have been opted out of the system. Now, one other aspect of the system which I won't be talking about is the new European patent with a unitary effect. And the driver for the system is the introduction of this new unitary right, which is going to have effect across most of Europe. Clearly, well, this will come into force, or the ability to designate a European patent as a European patent with unitary effect will come into force at the same time as the new court comes into force. The only jurisdiction into which this new European patent can be litigated, apart from the European Patent Office oppositions, will be in the new court. But because there won't be many European patents with unitary effect in existence in the first couple of years, I think most of the litigation is going to focus on the existing, the classical European patents which we know about. Before talking about that, let me give a flavour of where we are at present in Europe. And it's very hard to do this, actually, because there's very, very little transparency in Europe about patent litigation. We certainly have no European jurisdiction has a PACER system or anything equivalent like that, so you can follow the progress of litigation through the courts. In some jurisdictions, there is no public reporting whatsoever of court judgments. What one can do, the best one can do, is to piece information together from various sources, from various colleagues. Also, an increasing amount of academic research has been undertaken, where people have actually undertaken the hard work of working through dockets and trying to count numbers of patent cases brought. I cite there a particular study by Kramers, and you can get a flavour there of the different balance of patent litigation in Europe. We've got 100 or so cases filed in the UK in any one year, over 740 filed in the two major jurisdictions in Germany alone. And so you're going to be talking about 1,000 or so cases being brought in Germany. And I don't have statistics for the number of cases which actually got to trial in Germany, but you can look from the UK, and which is fairly good about publishing judgments, even if it doesn't publish the underlying data about cases filed. But those are some statistics for the UK. Gives you a flavour of the sort of the nature of the proceedings in there. One of those final hearings concerned Jamie's clients, and he was successful in that. And it may look from that as if it's not a terribly patent-friendly jurisdiction, but I would also emphasise that a lot of the actions brought in the UK tend to be brought by potential defendants because you can get an action challenging validity or seeking a determination of non-infringement onto trial very quickly in the UK, whereas, for example, you can't actually challenge validity in German proceedings of a European patent which is undergoing opposition. So there is an institutional trend in the UK of that one. Where do parties have patents? Well, I suppose the first point for any analysis of patent strategy in Europe is you need a patent on which to litigate. And nationally, there are remarkably few countries in which, in most sectors, patents are validated. The vast majority are only validated in Germany, France, and the UK. I think the Netherlands comes forward. And the approach varies by industry sector. In particular, the tech sector validates European patents in many fewer, I should have said, countries than the pharma sector. Indeed, in tech, sometimes patents are only validated in one country, and indeed that's reflected also in the fact that in the tech sector, patents may be prosecuted nationally rather than by the EPO, because you get an examined right, certainly in Germany and the UK, much more quickly than you would at the EPO. So you can't really talk too much about patent strategy, patent litigation strategy in the abstract without recognising that your hands are going to be tied by the circumstances where the patents actually are validated in Europe. Now that, of course, will change in the future with the unitary patent if there is uptake of the unitary patent. But for the moment, that's the situation we have. And that, for example, is why I haven't said anything about the Netherlands on this slide, identifying a few procedural differences between jurisdictions. As Mark said, the Dutch system is a very good, fast, effective system with expert judges. However, not that many patents are actually validated not as many patents validated in the Netherlands as in these other jurisdictions. And I've outlined there a few of the procedural differences. I mean, but there are massive, you could have a talk alone on procedural differences, a massive number of procedural differences. But in Germany, you have fast infringement courts, slow nullity courts. You've got the bifurcation, you've got the split system, so that the infringement court cannot invalidate it, but can stay proceedings if it's presented with a prima facie strong challenge to validity. And as I say, you can't actually challenge validity of an EPO patent whilst there's an EPO opposition ongoing. And EPO oppositions can take for ages. In the UK, the courts are fast, not quite as fast as the German infringement courts, but they do have the benefit of allowing you to deal with infringement and validity together. And they were certainly prepared to review validity if an EPO opposition is ongoing, and will not stay proceedings, for example, if an EPO opposition is ongoing, unless a determination in the EPO is almost imminent. UK also has a very low standard of establishing locus for a declaration of non-infringement. You can effectively establish that by means of the procedure adopted in the UK. And there was a case last year where somebody did that in the UK and got a declaration of non-infringement, not only in relation to the UK, but also in relation to France, Spain, and Italy, where the locus for establishing, securing a declaration of non-infringement would have been rather higher, the threshold would have been rather higher, and also the court procedure would have taken a lot longer. And France, even though it has a lot of patents validated there, you don't see so often in international patent litigation, I think, because the procedure's rather slower than it is in Germany or the UK. I should have said Germany or the UK. And the decisions, they transport less well because they are less fully reasoned. So, with that brief word about the situation now, let me just close the last few slides with where we are going to be in the future and what this unified patent court offers for us. Opposition at the EPO will continue as a possibility. It'll be interesting to see how the new unified patent court actually affects the take-up of opposition at the EPO, because for the first time it will offer the prospect of revoking a European patent on a centralised basis for all countries in which the patent is designated at any time of the patent's life. So that does compete with the opposition procedure, and the timing for the Unified Patent Court, it should be an awful lot faster. We're talking, in theory, about an action which should only take a year or so. But what we're going to face in terms of putting together any strategy is this tremendous complexity we have, in that there's going to be the possibility of litigation in national courts, there's going to be the possibility of litigating in the Unified Patent Court. I've listed there the various patents which are going to be open to litigation in national courts in future, and litigation in the Unified Patent Court will have the unitary patents once these start to come through, but the default position, if people do not opt out of the Unified Patent Court for their existing European patents, will be that those get litigated in the Unified Patent Court for those countries which are participating in the Unified Patent Court. Now, I've said that's 25 countries have signed the Unified Patent Court agreement. It will come into effect once 13 countries have ratified it, including France, Germany, and the UK. This means that quite possibly for an interim period, the effect of the Unified Patent Court will not cover all those 25 countries. It will only cover those countries that have initially ratified it. So this is going to be a somewhat movable feast as to whether you're going to be able to litigate in the Unified Patent Court. Very briefly, and all I can do really is give you a flavour of not only the complexities between the national courts and the Unified Patent Court, but the complexity within the Unified Patent Court itself. You've got the central division, which can take nullity suits and has a limited jurisdiction in relation to infringement suits, and also can take declarations of non-infringement. But the real powerhouse in this system will be litigation taking place in the local divisions or the regional divisions, and none of these have been settled as yet. Countries can opt for these. I've set out there what the current thinking is, but that could easily change. But it does mean that there will be all of these different local regional divisions, possibly with different amounts of national flavour to how they deal with the procedure, although there's a common set of rules, and there is a common appeal court which should act as which should even out the differences. But it's a system which tends, I think, to be plaintiff-friendly, institutionally plaintiff-friendly, in that the local or regional divisions will take precedence over the central division. And, for example, if you start a revocation or a declaration of non-infringement in the central division, the local or regional division can then stop that if an infringement action is started in a particular local or regional division. There's been a lot of talk and concern about bifurcation. The system certainly does permit of bifurcation. There are some provisions in the rules which are meant to establish that where the bifurcation does take place, the determination of validity happens before the determination of infringement. That is encouraged in the rules. Whether that will actually happen in practice, we don't really know. And as I say in this slide, the scope for the defendant preemptively to challenge validity or seek a declaration of non-infringement can be frustrated if an infringement action could be founded against them. So what we're going to have is not only the system we have at present, which is forum shopping as between different national courts where there are patents in force, but we're also going to have the prospect of forum shopping as between the UPC itself and the national courts. And within the UPC, there's going to be an element of forum shopping as well, because different divisions will have different expertise. There are clearly likely to have somewhat different attitudes. There are provisions which are meant to moderate that. For example, the divisions with a history of more patent cases will have a preponderance of local judges, 2 judges and only 1 sort of centralised judge. But those less expert jurisdictions will have only 1 local judge and 2 from the central pool of judges. But what we've done in the short term, the 7 to 14-year period, is create an extra tribunal, an extra layer of complexity, an extra consideration to feed into the pot of putting together your strategy of litigating in Europe. So if you think it's complicated now, it's going to get a whole lot more complicated in the future. Thank you.
Thank you, Trevor. Shall we do a seat?
So I'm going to pick up where Mark left off here and talk a little bit about some of the nuts and bolts of doing multi-jurisdictional patent litigation and what we've learned at Gilead, being a multinational pharma corporation, and what we've learned over the last few years in terms of managing and assessing opportunities for litigation outside the United States and how we manage it and how we think about these things on a strategic level. But before I do that, I wanted to add one thing to what Mark said. He was talking about sort of the emergence of ex-US patent litigation and sort of some of the reasoning behind why we're seeing a surge we're seeing more patent litigation going on outside the United States, and he touched upon unfavorable, some unfavorable aspects of the United States with regard to injunctions and discovery and globalization of the supply chain. One other point I would add to this is the growth and emergence of a middle class in middle income countries that didn't exist 10 and 20 years ago, that are creating new global markets that simply didn't exist. And with the emergence of those markets come competitive opportunities, and with competitive opportunities come the importance of patents and patent enforcement. So I think that's, especially in the biopharma space and the medical device space, that emergence of a middle class that wasn't commercially significant 10 and 20 years ago has led to some of that as well. So just one additional point I'd add on to Mark's excellent point, observations that he made. So looking at sort of the when, where, why, and how of multi-jurisdictional patent litigation, one of the things that we always try to keep in mind is what are we trying to achieve by this? Because these litigations tend to be very expensive, very public, very important, and your underlying theme of what you're trying to accomplish with your litigation has to be kept in mind. For example, if you simply want to obtain FTO for a particular product in a particular jurisdiction, and a counterclaim might be filed against you against one of your patents, and if at the end of the day you need FTO, you might not care about the validity of your own patent. Are you asserting infringement? Where can you get an injunction that would hurt and maybe force the parties to get into settlement discussions, and really thinking about how this fits in with what might be a greater global dispute or commercial dispute between the parties, and understanding how this is one piece of that dispute and how that fits in. Another thing that we give a lot of thought to, especially in the pre-litigation preparation process, is thinking about remedies and timing that I've identified here on my second slide. Outside the United States, as Mark mentioned, there can be access to remedies that we don't have here in the United States. For example, there can be a presumption that the losing party is going to end up paying attorney's fees, which is obviously not the rule here in the United States. There's also going to be access in many jurisdictions to disgorging of profits from an infringer that we don't have available to us here in the United States as well. So understanding the differences in remedies, and then Mark also touched on injunctions and places like Germany where you don't have the equitable considerations in the issuance of an injunction the way you do in the UK, the US, and other common law countries, Australia and Canada come to mind. And so bearing that in mind, that an injunction could very well issue as a matter of right and not upon the balancing of equitable considerations that you would see here. Timing. One of the points I would emphasize on timing is where can you go in your litigation strategy to get an early win in the process. An early win, is fantastic for your team morale. That you feel that you're doing the right thing for the right reasons, and getting an early win can be very, very valuable for that. It can also be persuasive in subsequent jurisdictions as you work through your different countries, and you're able to point out to subsequent judges what past judges have done and ruling on particular issues if there's sufficient overlap in the issues that are being litigated. And also early wins can trigger early and favorable settlement discussions that go on to resolve the dispute. When we're looking at these disputes, we're also thinking about the judicial system that we're going to be in. The first thing we're thinking about are the judges and the lawyers in a particular country. When you think about the judges in countries such as the UK, when you have a Category 4 or 5 case in the patents court, you have two guys there that are extraordinarily competent. If you end up in Dusseldorf, you're going to have great judges in Dusseldorf. You litigate in the United States, in Delaware, and New Jersey, you're going to have very sophisticated, competent judges that have seen many, many patent cases. There's going to be other courts, for instance, France, it's going to have a specialized IP court. And then you're going to end up in other courts that might be courts of general jurisdiction. I've got experience litigating in Scandinavia, where you've got a court of general jurisdiction. The United States is a court of general jurisdiction in federal court. And if you end up in most jurisdictions in the U.S., they see a smattering of patent cases if you're not in Delaware, New Jersey, or a couple other places. And so understanding what sort of the competence and the experience of the judges are and where you're going. And then also what does the patent bar look like in the particular country you're litigating in? Are they sophisticated enough to handle very complex multi-jurisdictional cases? There are some countries that have a very small and limited patent bar. There might only be 4 or 5 legitimate law firms in a particular country that can handle your case. So conflicts become a problem, and getting your preferred counsel can be an issue as well because the patent bar is so limited. It's not, even in the UK, you have limits on on which firms you're probably going to go to on a major patent matter. In the U.S., it's completely different because there are so many good choices to turn to in the United States. And then also in some of the smaller jurisdictions, what is the relationship between and the knowledge of the judges from your lawyers that you're getting? What kind of relationship do they have? What kind of knowledge do they have about the court system is very important in some of these smaller jurisdictions. Some of the other things that we're thinking about here when we're assessing multi-jurisdictional litigation is the likelihood of success on the merits. Really having a firm understanding of how strong our positions are in a particular jurisdiction, because the strength of those arguments can change from country to country, and understanding where you might be a little weaker on infringement or validity based on what the underlying law is. Also, being in the biopharma space, there are some jurisdictions, places like Canada and India come to mind, that are sort of inherently, have sort of an inherent public policy that is anti-innovative pharma, and understanding that's the structure, the framework you have to litigate within, and how does your case get put together, if it gets brought at all, in some of these places where you have a lower likelihood of success. And then the final point here is on this slide is thinking about the parties. Who's going to have to be involved in the litigation? Do you have to enforce or defend your patent with a licensee or licensor? How is that relationship? And are they going to be cooperative and available to prosecute the litigation? And in that licensee-licensor relationship, what is the underlying agreement for controlling the litigation, sharing the costs, sort of the practicalities of running a litigation with another party? And then also, are any of the parties either on your side or the other side of the V in their home jurisdiction? The French courts, I think, are notoriously favorable to French litigants, and we've had some experience in China where the Chinese courts tend to be a little more favorable to homegrown entities than foreign entities in there, but that's changing as well. So those are other factors that we keep in mind. I think this slide, all of these points are sort of self-explanatory. The last point I will talk about on this slide is, and Mark touched on a little bit in his remarks, is the availability and desirability of alternatives to litigating in court. And do you have an option to go to the national or regional patent office to challenge a patent? Is it faster? Is it non-public? Factors that you might want to keep in mind for alternatives. And then Mark also touched on customs agencies and seizures, that, whether it be in Europe or through the U.S. International Trade Commission. That offers you options as well to think about in your enforcement scheme. And it's not just about going into court and litigating. To think about your other options. Other things we're thinking about, if we kick off a multinational litigation, are we exposing ourselves to potential counterclaims, either on the same technology or something unrelated? And a story comes to mind, the Sony LG litigation that went on. Sony sued LG on some cell phone technology in California, in federal court in California, and LG responded asserting some of its patents of the Sony PlayStation in Europe and in the U.S. And so the litigations were completely unrelated, but Sony may have bought itself some litigation by asserting the cell phone technology and ended up with litigation in its PlayStation 3. So thinking about where you might have risk on a counterclaim and in which countries is something that needs to be kept in mind as well when you're thinking about these multi-jurisdictional litigations. And then a few points down below about litigating simultaneously in multiple places at the same time. In terms of diversifying risk, if you lose in one jurisdiction, you still got sort of other eggs in the basket, if you will, for potential wins in other places. And I can speak from experience that litigating in multiple places simultaneously raises everything I have on this slide, the pressure, risk, complexity, and cost, not only on the opponent, but also on your side as well. It gets extraordinarily difficult to keep everything organized and consistent. And then finally, we've seen this with the litigation I've been involved in with Jay, on a case that's now been litigated 3 or 4 times. Each time it gets litigated, your opponents have an opportunity to do it a little bit better. And you're going to see that that as cases get litigated, you're going to get better at it, they're going to get better at it each time you have another opportunity to go over the issues. Mark touched a little bit on discovery in his comments. I won't say much about this, but be aware of 1782. If you're litigating outside the United States, that you could very easily get hauled into court to put up witnesses, provide documents, or answer any other form of discovery that's available under the federal rules. We've used it, and we've been on the receiving end of it. It's very effective. And then one of the issues that we face a lot in thinking about it, and we struggle with, is how do we use discovery across jurisdictions? And I don't know that there's one easy answer for that, because there are so many competing limitations on it in terms of U.S. protective orders, confidentiality, club orders that get implemented in the U.K. There's something called the implied undertaking in places like Canada, and that places a very significant and affirmative limitations on how you can use your discovery outside of the jurisdiction where it was provided. And then the final point here is that give some very serious thought to entering into an agreement with your opponents on the other side on the free use or not of discovery across jurisdictions. The last 2 points in this slide: attorney-client privilege waiver. If you waive in one jurisdiction, it's probably going to be a waiver everywhere. And so we're also looking at issues of attorney-client privilege in different jurisdictions to make sure it's adequately protected before we kick off litigation there. Civil law countries, and I think Trevor would probably agree to this, that a lot of civil law lawyers are just not accustomed to getting the huge document dump that we have in places like the UK and Canada and the US. And they will spin their wheels and just get completely lost in the documents because they're just not accustomed to having this volume of information. It'd be a little bit like telling a U.S. lawyer to go litigate with no discovery. Your first question would be, how do we do this? That's exactly what the civil lawyers face. So keep that in mind as well. Moving along here, the second point here is the scope of discovery. It's something you have to always keep in mind when you're litigating outside the United States. Are you looking for a lot of discovery? Do you want to limit discovery? What side of the argument are you going to be on, and where are you going to be, and when for documents for discovery obligations? I've tried to list up a little bit of a hierarchy in terms of what we've seen for the scope and burden on discovery, with the U.S. leading the pack and the Canadians and the Brits not far behind in terms of discovery obligations. And in Australia, it seems to be a bit of a grab bag that you can be subject to discovery, but it's at the discretion of the court. And then e-discovery can be its own monster, and we can talk forever on that. But understand the scope and significance of your e-discovery obligations outside the United States. And then my last 2 slides here are some of the high-level sort of takeaway critical components that we think about, as we're putting together these cases, and sort of our lessons that we've taken away from this. First and foremost, when we're looking to hire counsel, we try to hire the very best counsel in each country by country, and not so much of hiring a global law firm that can represent us in 5 or 6 countries, but going country by country and hiring the very best in each jurisdiction. Going out of our way to build frequent and open communication with counsel, having frequent telephone calls with all global counsel on the call every week or 2, having global summit meetings where we bring global counsel all together in London on a particular dispute every 6 or 8 months so that we can strategize and folks can get to know each other and we can share information. It's really important that people have access, that global counsel have access to each other for information sharing. Experts, just can't emphasize them enough. They're as important outside the U.S. as they are in the U.S. Get your experts retained early. If you have the benefit of being the first mover where you're initiating the litigation, the other side doesn't know you're coming with it, get your experts lined up, get as many of them as you can get lined up, and understand some of the interesting rules around experts. Each country has their own set of unique ways that they handle expert witnesses in terms of their retention and preparation. You have to be respectful of that. For example, you would never use the same expert in the U.S. as you would in the UK. It's just bad strategy, and so you have to have redundancy in your experts, and you have to have them handled correctly. And then finally, there are going to be some countries where you're going to need an expert to speak the native language. If you litigate in Spain or Russia, it's going to be very, very helpful and beneficial if you have a Spanish-speaking or Russian-speaking expert to be in front of the court. And then I spoke a minute ago on the first mover advantages. Get your counsel and get your barrister teams lined up early before the other side knows you're coming. Get your experts lined up. And then the last 2 points I think are really important in global litigation and just can't be underemphasized is you have to be bold and courageous and you sometimes have to drop great arguments in certain jurisdictions because it will hurt you in other places. And that's part of what our job is as in-house counsel, is recognizing that when we need to drop an argument that's going to in a smaller jurisdiction, although it might be a winning argument to win the case in a small jurisdiction, if it's going to hurt us in a commercially significant jurisdiction, we're going to have to pull that argument back and not run it. And then finally, last thing I'll say here is to let local lawyers run a local case. As U.S. lawyers, I think we are all far too eager to assert U.S.-style advocacy into non-U.S. systems. And it is a round peg in a square hole. It doesn't work and it doesn't fit. You need to hire and trust the very best lawyers in each jurisdiction and let them run their local case and not try to manipulate that process with the way we do it in the U.S. and let the local lawyers run a local case.
Jamie, thanks so much for your remarks. I thought one of your takeaways is never engage a law professor as an expert, but thankfully that wasn't on your slides. One interesting choice that Gilead made, speaking of patent enforcement, was the choice not to enforce your patents on your revolutionary Hep C drug. And so I believe you've licensed, 90-some developing countries, 11 generic firms in India alone. What can you talk about the strategy for that grant and some of the complications that resulted from it?
Yeah, so Gilead has, about 10 years ago, Gilead started what was known as the Access Program. We are currently the leader in HIV medications, and we saw a very, very severe unmet need of getting our drugs into some of the poorest countries in the world where we didn't have any supply chain capabilities. But yet there was a very clear unmet need in terms of HIV therapy in places like sub-Saharan Africa. And so what we did with our HIV portfolio of drugs is we licensed about a dozen Indian generic companies that had supply chain capabilities into some of these smaller markets in sub-Saharan Africa, Central Asia, and some of the poorest regions of the world. And so what we did was we licensed we licensed 11 generic companies to sell product into the 91 poorest countries in the United States, 91 poorest countries in the U.S. as established by the United Nations. And that has had the benefit of allowing our HIV medications to get into these poor countries. And when you have 11 companies competing for this business, it drives the price way down. And so the patients have access, and they have it at very competitive prices that are not much more than the fixed cost of that the generics have to bear. And so we took that model and implemented it for our hepatitis C cure that was approved in the U.S. about 15 or 16 months ago. We've got 2 products that are available now on the market in Western Europe and here in the U.S. for a cure for hepatitis C. And we licensed that exact same model so that there could be access in some of the poorest countries in the world that have a very high burden of hepatitis C. But this has then created its own problems with the licensing program because these drugs tend to be extremely expensive outside of the access countries. And so what we've seen is, and we try to prevent to the best we can with various enforcement mechanisms, either be patent enforcement, trademark enforcement, but we see occasionally diverted product that come out of the access countries that end up in legitimate commercial markets. that are not part of the licensing program, and so we've got other mechanisms, IP mechanisms, typically to counter sort of the diverted product that ends outside of the access program.
So I'll try to take a question from the audience if there are any, and while you're warming up your questions, I'd like to ask one of Trevor, if I may. I thought in the United States it was a good time to be a patent judge because the USPTO, I think, has hired many dozens of them, and I literally can't walk down the street without calling someone judge these days. But my goodness, how many jurists? I don't think you'll find that many judges in all of Europe to fill all the posts that are. Trevor, you may have to repatriate. Where are they coming from, and is there that much business?
Well, I don't know how much business there will be, but I don't think there's any shortage of potential judges. There was a call for expressions of interest, and I think they got about 1,500 applicants across Europe who did express interest. Now, not all of the only a proportion of those had any expertise in patent law, and those judges which do not have such expertise, and you can anticipate this happening in a number of countries in Europe where there is no existing expertise amongst the judiciary. There is a program underway now for training up these judges. So, but any panel will certainly have one or two, two well-experienced judges. So it's only going to be one member of the panel will be, if you like, a sort of trainee from that point of view. But no shortage of judges, potentially. Although they haven't yet been told what they're going to get paid.
The lights seem to have risen in intensity, and I'm not sure if that's supposed to be akin to the vacuum cleaner coming on at the end of the night. But are there questions from the audience or other comments? Okay, great. Well, we'll have a chance to discuss with the panel afterwards. Seeing none, please join me in thanking my fellow. Oh, we have one, please.
So, Mr. Davison, and this may or may not be as proposed to the actual subject of the panel. But with the drug hepatitis C and model for going into that global space by driving a licensing program, the hepatitis C drugs, the two drugs you have, which are very innovative, what are the implications with regard to liability if there are complications? Say, again, these drugs are now made by third parties, you've licensed, and they're actually used in combinations that have unexpected outcomes and potential damages associated with side effects and so forth. And does that factor into how you structure the licensing or how you put those programs in play?
Yeah, so I'll have to admit that product liability is a little out of my depth, so I don't know how that's addressed on the product liability issues.
Okay, well, fair enough. Well, look, again, since if my students know, I keep everything moving on time. So let's thank my colleagues here on the panel for the presentation.
Well, thank you very much for the quick turnaround. Thank you for all to all the panelists and moderators previously for a very interesting morning. I recognize that this panel stands between you and lunch. We are going to do our absolute best to be efficient and to continue to be on time, but I certainly don't want to rush this because I think we're in for a definite treat with our two speakers and also our subject matter. The topic for your third panel is patent law developments in the Supreme Court and the Federal Circuit. You could easily spend an entire day talking about this subject on its own, and we have two true subject matter experts to talk about the many issues that have been bedeviling the courts in recent months and years. To my immediate right is Nathan Kelly, who's the Solicitor and Deputy General Counsel for IP Law at the USPTO, and in that capacity he counsels the PTO and defends decisions of the Director, the Patent Trial and Appeal Board, and the Trademark Trial and Appeal Board in the federal courts, and his office also represents the PTO in various interagency deliberations on IP-related matters. And to Nate's right is Suzanne Monk, who is the Chief Counsel for IP for the U.S. Federal Trade Commission, Deputy Director of its Office of Policy Planning. She has focused at the FTC on several policy efforts, including the 2009 report addressing follow-on biologic competition and the 2011 report concerning the evolving IP marketplace. And of particular relevance to us today, in December 2012, Suzanne led the FTC's efforts in a joint workshop between the FTC and the Department of Justice exploring the impact of patent assertion entities on innovation and competition, and she's the lead attorney on the FTC's study of this area. My name is Mark Fleming. I'm a partner at WilmerHale. I specialize in appellate and Supreme Court litigation. I work out of Boston, where I'm pleased to report it is still January. And I'm very grateful to Professor Thomas and Dean Traynor for the opportunity to come down and have a taste of spring here in Washington, although I gather even you had snow a few days ago, but there's no sign of it anymore. As you can tell, these two really know their stuff. We're in for a real treat. Both of them are speaking, just to be clear, in their individual capacity. Nothing they say should be taken as expressing the views of their offices or their colleagues or the U.S. government, but even their personal views will be very illuminating. The only drawback here is that we only have an hour. We have made some choices about what we plan to cover. I'm skeptical that we'll get through even what we plan to cover, but we will do our utmost. I think we should start, Nate, with an issue that's really gone from completely dormant to absolutely explosive in the last 5 years, and this is the issue of patent eligibility under Section 101 of the Patent Act. We've basically had a Supreme Court decision a year on this topic, the first big one being Bilski back in 2010. We then had Mayo in 2012, Myriad in 2013, and then in 2014, Alice. Each time the Patent Office has had to adapt and readjust. So can you give us a sense of the landscape in which you're operating right now? And I know you have a few slides, so I'll give you the control.
Sure. Thanks, Mark, and it's happy to be here. And let me pick up right where you left off, which is the Supreme Court cases since 2010. What's interesting is that if you just concern yourself with the subject matter eligibility that's related to software and to business methods, the cases we all talk about are Benson, Fluke, and Deere, the BFD cases, if you will. And those three cases really came about in the early 80s, late 70s, and even before that. And in fact, the Federal Circuit case law on Section 101 was essentially dormant. And it went dormant in a very interesting year, 1982. 1982 was the year that the Federal Circuit essentially sprang into being, and what we saw is the Supreme Court step back from 101 and not do anything, essentially, for almost 30 years. But you're right, so in the past 3 or 4 years, we've had, it seems like, a never-ending string of Supreme Court cases, and they keep modifying the one before and keep pushing us away from where we think we were. So what I wanted to talk about this morning is Alice, and don't worry, I'm not going to go through the Alice decision one more time for everybody. I'm sure everybody's familiar with it by now. But I want to talk about its outcome and what we've seen since then. So just so that we are all at least on the same page, the claims in Alice were to a method of risk mitigation in sort of currency exchanges among multinational banks. So the idea was that as a bank goes through the day and it exchanges its currency with a foreign bank, maybe dollars for euros at one point and then euros for dollars later, that at the end of the day, when all of these exchanges and trades basically come to fruition, the money is there. And you know, people have talked about the claims in Alice. They say, well, the claims in Alice were directed to the abstract idea of escrow. Well, that's not true, right? Escrow is where when you make a trade, you take your money and you put it in your lawyer's bank, and someone else puts whatever else in the bank, and then when everything's there, the lawyer does the trade. That's not what Alice's claims required. So as the invention worked in Alice, you went through the day, you made the trades, there was something called a shadow account. And the shadow account basically kept a running tab on the trades. And at the end of the day, when it went to clear, it would only clear the trades that there was still money for at the end of the day. What's interesting is that Alice's claims could have done the same thing in a different way, right? Instead of a shadow account, they could have actually authorized or not authorized the trades as they were made in real time during the day. So there were different ways of implementing that idea. So one of the arguments that was put before the Supreme Court was, this is not preemptive. There are other ways to accomplish this. In fact, it's a very, very narrow claim. And the Supreme Court, as we know, didn't really buy that argument. When we talked internally about what the Supreme Court would do in yet its next case, at that time it was going to be Alice, we joked that the test was going to be, are the claims directed to an abstract idea? And the second part of the test was going to be, are you sure? Now what we know that the test is first step, are the claims directed to an abstract idea? And the second step is that all? And that is really where we are. So we have the two-part test, and what Alice did for us is it really dispelled the notion that we're going to look at all of these issues in separate buckets. So Alice relied on Mayo, just as other cases had relied on different parts of the case of the court's eligibility analysis, whether it was for biotech inventions or for software inventions. And so now we have this two-part step, or two-step test that I'll get into in a second, and where the line is getting drawn by the Federal Circuit. I just want to briefly say that after the Alice decision came out, the USPTO issued new guidelines, and we followed the Supreme Court's lead in one important respect. We took our existing guidelines, which heretofore have been directed to biotech inventions separately from inventions that might trigger the abstract idea exception, and we put them together in one set of guidelines, one flow chart, if you will, to really come to grips with how the Supreme Court is dealing with this area of the law. We also took the opportunity to update our guidelines that had come out after Myriad, and I'm not going to get into that, but that was one of the things we tried to do in our recent guidelines. And the other thing we tried to do, and I was an examiner back in the 90s, and I didn't see this go on a lot in the guidelines that were issued then, but it's something we really try to do now. It's something Director Capo started, and it's something we continue to do, is that we're not just going to issue our guidelines, but we want to give you examples. And we don't want to just give you a bunch of examples of why things aren't obvious or why things aren't eligible, but we want to give you examples for both sides of the line. And so what we did in Alice is, following Alice, is that our guidelines have substantial examples for our examiners to use in favor of eligibility and against eligibility. Because the key here is the line drawing, right? The Supreme Court, when it issues one of these decisions, basically steps back and gives us 9 pages of a generic concept, an abstract idea itself, if you will, that we all then have to move forward and rigorously examine, and it's difficult to do. And so before I get to the next slide, I want to tell you something that we did inside our office. It's not something that's official or something we've come out with that you could see anywhere. But because we were curious, we had one of our attorneys go in and examine district court decisions based on software claims post-Alice. And we looked at 3 periods. We looked at the period 8 months after Alice came out. And we didn't look at what you might think is the next logical period, which is 8 months before it came out, because we were then dealing with the Federal Circuit in-bank decision, which is, I'll say, a mess. So we looked at the 8 months prior to the Federal Circuit's in-bank decision in Alice, and we also looked at the 8 months prior to Mayo. And here's what we found. In the 8 months post-Alice, there were about 50 101 decisions by district courts. 38 of those cases were held invalid, and 10 were held valid, or I should say not invalid, and 2 were split decisions. The important point is that it was about 3/4 of the cases were found invalid under Section 101, and there were about 50 total cases. If you go back and you look at the pre-Federal Circuit in-bank decision in Alice, the number drops down to 11, and 2/3 of the 11 were found invalid. If you back up to the 8 months before Mayo, and I think you can make a strong argument that the Alice decision simply takes Mayo and puts it into the abstract idea analysis. There were, again, 11 cases, but this time 72% of them, or 8 of them, were found not invalid or valid for normal people. So you do see a shift. You see a shift in the decision, and you also see a shift in the number. And I think that is just going to keep going. So, like I said, the important part is where we're going to draw the line, what's going to be eligible and what's going to be ineligible. And there's been a handful of decisions post-Alice by the Federal Circuit, but only 2 of them really show us bright points and precedential decisions on opposite sides of the line. One of them was ultramercial. You can sort of think of the case as the third time's a charm. This is the case that the Federal Circuit kept issuing over and over again, and it wasn't until Alice that they finally found the claims to be ineligible. Ultramercial had the patent that does the thing that is so frustrating. It's why every time we click on a Washington Post set of photographs or a video, we have to watch that ad for mattress discounters. or every time we go to CNN, we have to watch an ad for something before we can get it. Ultramercial, according to the district court and the Federal Circuit agreed, incorporated the abstract idea of trading ad time for money. And the Federal Circuit ultimately found that was ineligible post-Alice because the additional requirements, the additional limitations in the claim simply were the stuff, the routine stuff that you had to do to implement the abstract idea of making someone watch an ad before they got the content. On the other side of the line is the DDR case. The DDR case was drawn to basically an e-commerce method. The idea was when you're in one website and you click on a product that's linked to another website, you don't actually go to the other website. You stay in the first website you're in, and it quickly creates a page that looks identical or gives you the look and feel as if you've gone to the other website, or as if that, I should say, that product has come to you. So if you're on Amazon.com, you click on a product that's at one of its related websites, you don't go there anymore. You stay on Amazon, and they strip out all of the information from the partner's website and create a website that looks like an Amazon site. And that case was held eligible. And what's interesting is how the court treated the additional components in the DDR case. What the court said was the claim limitations were transformative because the process patented overrides the conventional click. In other words, what the court was saying was this fine line that you've now crossed over is you've taken conventional and routine things and made them work differently. You don't actually go anywhere when you hit the click anymore. Now you stay here. And that little difference is what made the claims in DDR transformative and the claims in Ultramercial not transformative. The one last thing I'll say is if you want some quotables from these two cases, the concurrence by Judge Mayer in Ultramercial is full of them. He says things like the Supreme Court has now given us a technological arts test and that patentability resides in inventions that are technological and not entrepreneurial. And I think that is an interesting quote to bring forward. So that's all I'll say on that.
Thanks, Nate. I do have a follow-up question, but first, Suzanne, do you have anything you'd like to add to or comment on the 101 issues?
No, I thought that was a very good presentation.
So, Nate, can I just ask, what now is the status of business method patents? Because it seemed like one of the ways that Alice could have been decided, and in fact, Justice Sotomayor's very brief concurrence sort of indicated that she might have viewed this as an appropriate case to wipe out business method patents altogether, and she got two other justices to sign on to that view, and it follows on from the four-justice opinion in Bilski. Is there an argument now that business method patents will always fail this two-step test, or is there some room for those patents to continue to be issued in your view?
I think the difficulty in answering that question has to do with what you think of as a business method patent and what I think of as a business method patent. If it's what Judge Mayer referred to as an entrepreneurial idea, if it's basically a business concept that you put a general purpose computer on, I think you're going to have a very hard time with those kind of claims moving forward. But you also can call a business method invention something like an adding machine or some technological situation that is amenable to using in the business place, in fact, directed to using in the business place, but is nevertheless something technological. And I think that that's the line that DDR tried to draw for us.
Great, thank you. Let's move to the fallout from another couple of decisions from last term, the Octane Fitness and Highmark versus Allcare cases. And Suzanne, I'm going to look to you for these. These are cases that had to do with, at least according to the conventional wisdom, liberalizing situations in which infringement defendants could seek recovery of attorney's fees when they're successful in defeating an infringement claim, and also giving greater deference to the decisions of district judges on those fronts, review now for abuse of discretion rather than, in some circumstances, de novo. And I think the thinking, at least in the industry and the academy, was that by making it easier for defendants to get fees, that would help curb some of the perceived abuses in patent litigation. How's that working out from your perspective?
Well, I mean, I think to sort of understand Octane and Highmark, you want to take a step back and look at exactly what the Supreme Court was doing there, because I think there are two ways that people look at Octane and Highmark. The first is they say, now we're going to see just a rush of fee awards, and it's going to change the situation, and you're going to see a completely different landscape in patent cases than you see in the remainder of traditional litigation that follows more of the American view. On the other hand, people say, well, it's going to be very limited, you're not going to see very much. And so I think it's important to go back and look at what the Supreme Court actually did. And as you mentioned, what we're talking about is 285, where the language is simply, in exceptional cases, courts may award reasonable attorney's fees to the prevailing party. And over the last 10 years, you didn't see much application of this principle because the Federal Circuit had taken the position that in order for a fee award to issue, you needed to essentially have objective and subjective baselessness. And we all know what a high standard that is. So really what you have happening with Octane and Highmark is removal of that very high standard. So you can expect to see more cases sort of regardless of what happens, because it's hard to be, I think, stricter than objective and subjective baselessness. So in Octane, the Supreme Court was addressing what it meant to be exceptional under 285, and it said that to be exceptional under 285, a case is simply one that stands out from others. So you're seeing a much lower standard with respect to the subjective strength of the party's litigation position or the unreasonable manner in which the case was litigated. And it also said that when you're looking at exceptional cases, when you're testing exceptionality, you need to look at the totality of the circumstances, so all of the facts in the case. An interesting thing that the Supreme Court did more specifically is that it removed the Federal Circuit's clear and convincing standard, saying that that was too stringent in favor of a preponderance of the evidence standard. And without going into too much detail, you see similar analysis in Highmark, which was looking at the standard of review for attorney's fees awards. Now the review is a matter of discretion. So in going back and looking through the cases that have been decided after Octane and Highmark, you see some trends, right? If you find inequitable conduct, you're likely to have fees. If you see sort of a pattern of behavior that one would say doesn't represent sort of traditional litigation practice, you're likely to see a fee award. But these cases were decided obviously just last year, and I think it's fair to say that the district courts are beginning to work through the best way to handle these cases, but are definitely adopting a more liberal position than you've seen in the past.
And what's interesting, we did a little bit of research in preparation, and you see the results up on the slide here. Fee requests in patent cases did increase significantly after the Octane and Highmark decisions. The percentage of requests granted, however, stayed about the same. We're talking about 22% of requests tend to be granted, and it's still the patentees who have the greater success getting fees, notably in cases where they succeed in proving willful infringement.
Right.
About 17 of the 26 patentee requests for fees were granted, whereas on the defendant's side it was about a 1/3 success rate, 23 out of the 75 that were made. Now 75 requests by patent defendants is a significant increase over prior years, which means the defendants are taking advantage of these new decisions to try to make the requests, but they're not being as successful as the patent plaintiffs are at the moment.
Right, and I think one interesting to think about is the incentives of the patent holder versus the defendant in trying to seek a fee award at the end of the case. I think the defendants may feel as though they're in the better position to try, unless you have, as you said, a willfulness decision when the patent holder would then want to seek a fee award.
One of the thoughts behind, as these cases were going up, was that a liberalization of fee awards in favor of defendants would make it less likely for patent plaintiffs to bring what were viewed as frivolous or strike suits. And I guess the one question is, it's probably too early to tell whether that deterrent effect is taking hold. But wouldn't it be predictable, or at least possibly predictable, that many defendants would still rather settle these cases than fight it out to the bitter end, risk that they might lose on the merits, they might win but not get a fee award, or they might win and get a fee award but have it not be collectible because the patent plaintiff might be judgment-proof?
I mean, I think that's always going to be a consideration for the defendants. I think an interesting case, I think it was one of the first cases decided after Highmark Octane, was the Lumenview Find the Best case, where awards were wherein a fees award was given to find the best after the Lumenview patent was found invalid post-Alice. And one of the things that Judge Coate from the Southern District of New York was saying in her decision there was looking at just sort of the pattern and practice of someone bringing what you called strike suits. They had sued, I believe it was up to 20 different defendants on similar views without sort of distinguishing patent claims. And so I think it's definitely something that people are watching to see how the trends shake out.
Nate, anything to add?
Yeah, another sort of narrative that's going on sort of behind the development of the law itself is sort of the interplay between jurisdiction in patent cases and the ability of district courts still to have substantial discretion. Mm-hmm. So, the case Suzanne just mentioned was in the Southern District of New York. That case might have come out differently if it was in the Eastern District of Texas. I don't know. I do know that I think about 20% of pending patent cases are in that district, and at least one judge in that district has about a fourth to a half of those. So to the extent that we have development in the law that gives district courts the discretion to shift the fees, as long as patentees can bring their cases in districts where they think that the likelihood of a patent fee shift is going to be low, even when the case stands out, that's where the cases will be driven. And it may be that decisions like this will simply drive more and more people to favorable district courts, because the criticism, if there is one, to where we're going post-Octane and Highmark is that there is no requirement that the fees shift. And I think that that's a discussion that people are having not too far from here. Maybe we'll get to hear about it at lunch today. I don't know.
Great, thank you. Let's move to another topic, which is the fallout of the Nautilus decision regarding the requirement of definiteness in patent claiming, which is something that I know has definite repercussions at the Patent Office and the examining court.
It does. It does, and I'll get to that as we go into it, because I think each standard, first the standard that the Federal Circuit used pre-Nautilus and the approach, I'll say, that the USPTO uses today are clearly inapplicable to the other tribunal. They just won't work. So before Nautilus came around, the Federal Circuit had arguably either a correct standard or a bad articulation of the correct standard. So the Federal Circuit many times would say 112 second, now 112B, requires that claims particularly and distinctly point out what the patentee regards as the invention, such that people skilled in the art will know the boundary of the claim. And that's a pretty accurate paraphrase of Section 112. But then what happened is, beginning with a case called Exxon, I think, the Federal Circuit started slipping into shorthand. They started saying, well, that just means it's insolubly ambiguous, that the claims might be difficult to construe, but as long as at the end of the day you can come up with a construction, that makes the claims definite. When this issue first went to the Supreme Court, I think in a case called maybe Aplera, the government filed a brief and said, you know what, the Federal Circuit is just using some loose language. Insolubly ambiguous isn't actually the standard. The standard is whether someone skilled in the art is reasonably on notice of the scope of the exclusivity. But by the time Nautilus came around, and in fact, if you read the Federal Circuit's decision in Nautilus by Judge Wallach, it's hard to see how insolubly ambiguous is not the standard, or was not the standard, because that case repeatedly said insolubly ambiguous over and over and over again. And at that point, there was no way to resist. The Federal Circuit had made insolubly ambiguous a standard. And the reason why that standard was so problematic for district courts and 112B analysis is this. If you get sued or you sue, what's the first stage of your district court proceeding, right? It's the Markman hearing. And you on the merits. And there'll be obviously a lot of fights beforehand that lawyers like to engage in.
Plenty to talk about.
And what do you got to do? You got to come up with a claim construction that saves your client, right? So if you're the patentee and you're trying to avoid prior art, you've got to find a construction that's narrow enough to save you, but broad enough to get your competitor's product. If you are a operating company and you have products that are asserted to infringe, you've got to come up with a construction that either avoids infringement or touches on the prior art so you can get to your invalidity analysis. Either way, there's no way that you're going in the door of the courthouse without your theory of what those claims mean, which means this. Any district court looking at a patent case is not going to just see one construction in front of them. They're going to see two constructions in front of them. And if the lawyers are halfway decent, each construction is going to look reasonable. And so how on earth could anybody under the insolubly ambiguous standard ever say that claims were indefinite when they themselves said, oh, the claims clearly mean this over here. Please, judge, adopt my construction. Once you say that, it's pretty hard to say that the claims are not amenable to any construction. And so the insolubly ambiguous standard essentially prevented 112B from ever being raised rigorously in a district court. And so in the Nautilus case, and by the way, if you're curious, the Nautilus case was an exercise machine basically, and the invention was the inventors found a way of getting your heart rate monitor more accurate. So when you move around, your body creates a lot of electrical signals inside of it, and your heart pumping creates electrical signals. And the inventors of this patent figured out that if you invert the electrodes on one hand versus the other hand, it'll cancel out the muscle signals while amplifying the heart signal. And so that's what the invention was directed to. It was a little circuit with two electrodes on each hand, like this blue and this blue part of the pen, and you put your hand around it. And the claim limitation said that the electrodes were in a spaced relationship to one another. That was the term that was argued to be indefinite. The district court said it was indefinite because space relationship could mean anything. It could mean infinitesimally small, and it could mean basically infinitely separated. And the Federal Circuit said, no, they got to be far enough apart so they're two different points, and they got to be close enough together so you're touching them. That's all it means. And they said so that it wasn't insolubly ambiguous. It went up to the Supreme Court, and the Supreme Court vacated but corrected the test, and they said the test is not insolubly ambiguous. That just doesn't demand enough precision. The test, and I have it there on the slide, but it collapses down to reasonable certainty. That competitors, the public, have to be reasonably certain as to what that claim means. And the Supreme Court didn't decide whether it was indefinite or not. They just remanded it back. So you get two course corrections from Nautilus. The first correction is that you've eliminated this problem of insolubility. You've eliminated this articulation of a test that absolutely requires that there be not even one construction, because that was sort of hindering the teeth that could have been in 112B. And the second thing you get is you get a test that's very well tethered to the patent itself, because insolubly ambiguous has nothing to do with the patent. It's just a phrase in the abstract. But the Supreme Court stressed, and I have that there on the slide, that it's reasonable certainty read in light of the specification. And so the Supreme Court brought the test back to where it should be, which is an analysis of the patent itself. So following Nautilus, we basically had 4 cases use it and apply it in precedential decisions by the Federal Circuit. And I won't go through exhaustive details on all of these, but I will point out that in each instance, the Federal Circuit has gone back to kind of a little issue that pops up a lot in indefiniteness and has resolved it. In the Warsaw orthopedic case, the issue was a relative claim term. So in that case, there was a limitation that tied this medical device size, if you will, to the dimension of human vertebrae. And the Federal Circuit said, well, that's not indefinite. It's relative, but that doesn't make it indefinite because the dimensions are tied to human anatomy. And as we know from reading the specification and talking to those skilled in the art, people would know what the human anatomy is. And that case basically goes back to an earlier case called Homedica, a case by Judge Rader where there was like a chair, like a wheelchair that went in the back of a car. It had to be sized to get through the passenger door of a car. And the court said that's not indefinite because even though doors all have different dimensions, we understand what they mean. And this is sort of the post-Nautilus reaffirmance of that decision. And then you get to DDR, right? DDR was the 101 case, and it also had a 112 issue in it. And the 112 issue is that when you linked to these other websites, the other websites would copy the look and feel of the original website. So it had this subjective intent or subjective view issue in the claim. And what's interesting about that is the only pre-Nautilus indefinite case that really slammed down on a claim for being indefinite and went into a lot of detail about it was the Datamize case. In the Datamize case, the limitation was aesthetically pleasing. So the claims were directed to a kiosk that was aesthetically pleasing. And the court said, you know, what does that mean, aesthetically pleasing? That's just subjective. You know, you say you like this, he says he likes that. There's no real standard to view this. You get to DDR, look and feel does not sound a whole lot more rigorous than aesthetically pleasing. But what the court said is, well, it's more than just look and feel. If we look at the patent, we see what the look and feel elements are, and the patent describes them. It talks about copying logos. It talks about copying colors. It talks about putting the page layout in the same way. It talks about how the frame should be designed. It talks about the mouse over effects, what will happen on the screen when the mouse goes over a particular link. So the court went through and said, yeah, it sounds subjective, and there's a certain subjectivity in it, but that subjectivity is tied to various features that are tethered to the specification, and that's what makes it okay. Interval licensing, that's a term of degree. Interval licensing had to do with something being unobstructively placed in front of your face on a computer screen. And so the idea was that ads could be put on the wallpaper around a window you're looking at. If you're looking at something on a page on the internet, the ad would be on the outside. Or they could be temporal limitations. I don't know if anybody's ever used this website Waze, but if you use Waze, it sort of drives you around kind of like a GPS, except it kind of does some crowdsourcing to go around traffic jams as they're happening. And every time you come to a complete stop, it tells you where Dunkin' Donuts is. Or at least it tells me where Dunkin' Donuts is. Maybe it tells you something else.
Starbucks.
Okay. And I don't go to Dunkin' Donuts a lot, but at some point I must have, so it knows about me. The point is that its unobtrusive way of putting up the ad was in the downtime when my car was at a stoplight and I wasn't needing to do anything. And that's the exact issue that was before the Federal Circuit. And the Federal Circuit said, well, what does unobtrusive mean? Does it mean, is it a temporal limitation, like right at that moment it's not bothering you? Or is it a spatial limitation? The party argued before the Federal Circuit that it was just spatial and it didn't have to do with the timing thing, so that when your car was stopped and it popped up, that wasn't what they thought was unobtrusive. But the court went in and looked at the prosecution history, actually an interview summary by the examiner, and they said, no, you know, during prosecution, you said unobtrusive was timing and location, and it was because of that the court found the limitation to be indefinite. So again, the court is not just looking at the phrase in the claim in the abstract to find out if they can resolve it, but they're looking at the entire prosecution and what the patent says to see if it makes sense. The last example I'll give is another example of existing knowledge in the art. So in the EDOS display case, which just came out about a week and a half ago, it was to an integrated circuit. The claim was to an integrated circuit, and it had all these layers on it. And one of the limitations was that there was a contact hole for the source wiring and gate wiring. And all that you need to know about that is that on the transistor, there's little different places that you need to make electrical contact, and the claim said a hole for those places. And you can see the problem is, did a single hole mean a single hole over multiple places, or did it mean one hole per place? That was what was argued to be indefinite, and the Federal Circuit said, well, the evidence in the case is that everybody skilled in the art at the time they read this would have understood it to mean one hole per contact. That's the only example in the specification. So even though you can come up with this alternative construction of the term, that's really not reasonable in light of what people knew in the art at the time. So again, they've taken the claim limitation, not in the abstract, but tied it tightly to the patent and to the prosecution history to find out it was not indefinite. The last thing I'll say is that the USPTO approaches indefiniteness during prosecution a little differently than courts do. You know, we've heard from the court several times, and I think it's quite logical that it's during prosecution that we have the best chance of making claims clear. If you go back and you look at a lot of those argued indefinite phrases on the previous slide, if our examiner had made a rejection and said, I don't understand what that means. It could mean one hole, it could be multiple holes. What does it mean? If the applicant had come back and simply amended or put on the record something very clearly, it might have eliminated the entire case. So before the agency, we approach the indefiniteness issue as questioning whether or not the claim clearly delineates the scope. And if we think it's unclear, our examiners are instructed to make a rejection. This went up to the Federal Circuit in a case called In re Packard. Now, In re Packard was pre-Nautilus, but the issue in that case was whether the PTO and the district courts have to use the exact same standard for indefiniteness, or could the PTO approach the claims a little bit differently? And the Federal Circuit approved of our MPEP provision instructing examiners how to approach indefiniteness, and basically said, you know, if the examiner puts on record in their case about what they think the claim is, why they think the claim is unclear, that does shift the burden to the patentee to come in, or the applicant to come in with some sort of statement or amendment. That we still believe that's true post-Nautilus. We don't think that Nautilus washed everything away, and I can go into a lot of very detailed analysis of the opinion why I think that's the case, but I won't bore you. But we still approach indefiniteness under our existing MPEP standard in 217302. And we probably still should if we're going to keep issuing patents with as much quality as we can. You know, we hear, and I don't want to go too off subject here, but, you know, I'm not ignorant of the debate about the quality of the patents issued by the PTO, about how that can be improved, about whether or not it needs to be improved. The one thing our examiners must do and should do is read every single claim in every single application that they issue. And 112B is something that they should rigorously apply. We can't find every reference, right? We can't know if everything's enabled, but we can at least take a stab at making sure every single claim we issue is as clear as it can be.
Thank you, Nate. Suzanne, any follow-up?
Sure. So I just wanted to talk about this case a little bit, taking a step back, because I think some of you in the audience might be asking, why is anyone from the Federal Trade Commission even on this panel? Or at least that's a common question that I get, right? And I think when you look at Nautilus, and when you take Nate's very good points about the importance of reasonable certainty, that's why Nautilus is such an important case. If you are looking at the position of a competitor and they are trying to assess the patent landscape, they have three options. They can try and seek a license, they can try and design around, or they can infringe and then challenge validity, later go to court, etc., seek a DJ, all of those options. The least expensive thing for them to do is to figure out what is covered, you know, in their potential product or in their potential invention, what is already covered. And then if they seek to design around, they need to know with reasonable certainty what's covered so that they can understand that their design around is not covered. And before I came to the FTC, I had a case that I loved because I didn't realize how easy and awesome it was at the time, but it had to do with oil filters and the annular flange on an oil filter. And the patent essentially covered a specific physical way of designing your flange. And so our client looked at that and said, all right, we're going to design a different flange. Fine, done, settled. That doesn't happen very often. And so one of the nice things about Nautilus is that by introducing this certainty, it allows the competitor to decide if they want to design around, or if they want to seek a license, you're starting those licensing negotiations on standard footing. We can look at my product, we can look at your claims, we can get an understanding, and we're going to talk about this in a little bit of evaluation of the coverage. And creating those options is something that the Commission has taken a position on in our 2011 report of the importance of patent notice. So I think it's fair to say that the Nautilus decision was consistent with positions that we've taken with respect to notice and taking a step back and looking at the larger role of patents in the competitive context. Thanks.
Thank you. So we will move to a discussion of patent infringement remedies, and there have been some significant developments in that area. But before I do that, I'd like to put the audience on notice that once we are done with this discussion, we will pause and invite questions from you on the subjects we've been discussing. So if you have a question about the substantive law of patent eligibility or definiteness, or about fee awards or remedies, get yourself ready to go and gather at the microphones so that we will make sure we have time before we adjourn for lunch and for Congressman Issa to get your questions and get the benefit of the wisdom of the panelists in responding to them.
So let's talk both about damages and injunctions as remedies for patent infringement. And the last few years have seen significant engagement by the Federal Circuit on both of these topics. There have been two major damages decisions in the last 6 months, the Vernetics decision and the Erickson versus D-Link decision, both of which we as a firm and I happen to be involved in. They were both argued by my partner Bill Lee. And in both of these cases, you see the Federal Circuit recommitting to the role of district courts and of the Federal Circuit to enforce Daubert to ensure that damages theories that are offered by patent plaintiffs do not claim damages that go far beyond the scope of what they claim to have invented. I'm not going to go through the decisions in detail, but in Vernetics, the court had wound up being a two-judge panel because the original panel included Chief Judge Rader, who in the interim had stepped down. But Judge Prost's opinion and the later denial of en banc rehearing made very clear that the patentee is required to apportion down not just to the smallest saleable patent practicing unit, but in appropriate cases where you have a multi-feature product that is the smallest saleable unit, the jury has to be told to apportion even lower to the most reasonable component that is practicing the asserted patented invention. And the court also separately rejected a theory that had gotten a lot of currency in the district courts based on the writings of a Princeton mathematician, John Nash, profiled and played by Russell Crowe in the movie A Beautiful Mind, which won Best Picture. I never really understood why, but I guess it was better than Gladiator. And the point there was, if you start with what was called the Nash bargaining solution, the theory would be that patentee and accused infringer would agree as a starting point to split the incremental profits due to the patented invention on a 50-50 basis, and there might be some further apportionment after that depending on the circumstances. The Federal Circuit said without further effort to tie the facts of the case to the premises of Nash's economic theory, then it was not proper to put the figure of a Nobel laureate and a 50-50 theory in front of the jury because it would be misleading. And in Erickson, the court confronted a number of issues, but I think most importantly for our discussion, the way in which juries should be instructed regarding standard essential patents and the valuation of those patents, and there was some discussion of those on some of the earlier panels. When you have a patent that is declared to be essential to the practicing of a technological standard, it's very important that the jury be instructed that the patentee is not entitled to damages based on the opportunity to practice the standard, but rather the damages must be tailored to the contribution of the particular invention. And not to the fact that the invention happened to be incorporated into the standard. There are many ways district judges can reflect those principles in their jury instructions, but the Federal Circuit makes clear in the D-Link case it's very important that they do so in order to avoid the phenomena of patent holdup. And there was also a discussion of the risk of royalty stacking when you have a standard that potentially implicates multiple different patents. It's critical that the jury be informed where the evidence supports it, that if the royalty for practicing a particular patent is too high, you could get to the situation where nobody can practice the standard in an economical way because they would have to pay far too much, and the standard would be deprived of its usefulness. So here we see, Suzanne, and I'll turn to you at least to start this off, a lot of clarity, I think, from the Federal Circuit about what can and can't be done in seeking patent damages. How does this affect the competitive dynamic from your perspective?
Well, I think the clarity is important because when we reached out to people to talk to them about the entire market value rule and other issues, we heard that there was significant confusion in implying EMVR in the reasonable royalty context. And it actually led us to recommend in 2011 that you should only apply EMVR in lost profits where it had initiated, not in reasonable royalty. And the reason why we came to that conclusion was the potential for overcompensation when you're looking at a multi-component product or a product that has several patented elements. And it goes to the point that you were making also with respect to royalty stacking. But if you take a look back, I think that the recommendations that we made were in line with how courts have viewed damages at least since the 1880s. And what's interesting about Erickson and Vernetics is that they both rely on this case Gerritsen v. Clark, which basically stands for the principle that when you are seeking damages for a patent that covers a smaller part of a larger product, you should only get damages for the contribution of your technology to the larger product. If you have this system of overcompensation, the concern is that you would later lead to sort of decreased innovation down the line because you could either have a problem of royalty stacking where there's no money left over, or you could have everyone rushing to seek to sort of have the first mover advantage with respect to patent damages. So I think one of the very interesting things, especially with Vernetics, is that the court was clarifying that EMVR is the exception, not the rule. It will be fairly unlikely that you're able to show that your patent is the basis for consumer demand when you're looking at products that can have tens of thousands of patents attached to them, and the importance of making sure that you're conducting that analysis through your experts. I think that was another very interesting thing that came out of Vernetics, was guidance for damages experts in how they should be conducting their analysis. And I think, you know, the Nash bargaining solution is obviously a very interesting sort of theoretical framework, but the way I read that case was correcting the expert to say, you need to tie your theoretical framework to the actual facts of the case. And I think that if they'd done a better job of that, you might have seen a different outcome.
That's probably right. Nate, anything to add to that?
Not really. I mean, obviously this isn't the expertise of our agency or mine, but it does sort of, in my own mind, raise a curiosity, which is the interplay between some of these issues. That, you know, I do know that the royalty phase of a litigation can be extraordinarily costly, and everybody's coming up with their own theories, and so it'll be interesting to see if we do get into a fee-shifting realm, how the fee-shifting analysis can focus perhaps on subcomponents of a case. Because one of the tricky parts of fee-shifting that I've been hearing about is that we never know when you have a prevailing party or when conduct stood out or didn't stand out. And when you get into a subcomponent of a case where people are spending an awful lot of money to put forward one of their theories or not, I guess we'll see moving forward if we can get fees shifted on that component of the case or not.
I think that also argues for bifurcation of the liability and damages phases. I think it's, you know, I know when I was in practice, it's difficult to say this patent is invalid, I don't infringe. But if I do, jury, I should pay X. And I think when you're looking at, so we don't have anything to present right now, but we've been kind of looking at the various damage awards presented by the plaintiffs and defendants in recent cases, and they are orders of magnitude different. They're just, you know, I owe $600,000, no, you owe $6 billion. And that's obviously hyperbole, but you're seeing that level of situation. And I think if you were able to bifurcate, that might help. I think giving greater guidance to the experts in terms of what the district courts require, and I think greater gatekeeping by the district courts in throwing out models that are unworkable is something that you're going to continue to see going forward.
And there's sort of been a parallel movement on the side of equitable relief as well. I mean, it's now, 10 years since the eBay decision. It's become a lot harder than it was before, when you previously had basically a presumption of an injunction once infringement was proven. Is the injunction now basically dead as a remedy?
I don't think so. I mean, I think what eBay was intended to do is to bring injunctive relief back in line with the way that it's applied in other situations. So the way I read eBay is to say any applicant for injunctive relief must satisfy the same four equitable standards. You're removing the sort of presumption in patent cases, but just sort of bringing it back into line. Now, one thing that you do here is it will be interesting to see what happens with SEP cases, because I think there is sort of general understanding that you see fewer requests for injunctive relief in district courts with SEP cases.
Standard essential.
I'm sorry, I don't mean to. So I'm talking about standard essential patents, patents that are declared essential to a standard, that are usually come along with something called FRAND encumbrance, which means that I will license these patents on fair, reasonable, and non-discriminatory terms. And one of the things that I've heard out, just sort of out there, it's not really any position that I've taken, but is that if you look at eBay together with what the Federal Circuit said in Erickson D-Link, and when they were talking about apportionment for standard essential patents, they were saying the patented feature must be apportioned from all of the unpatented features reflected in the standard, and the royalty must be premised on the value of the feature, not any value added by the standard's adoption of the patented technology. That if you take those two things together, that you may see fewer cases in district courts where people are seeking remedies for alleged infringement of FRAND encumbered SEPs.
Follow up on that? All right, as promised and threatened, are there any questions from the audience on any of the topics we've covered so far? We have a little bit more material, but I'd like to pause now and allow you all to raise any thoughts that you have. Comments, objections? Yes, sir. Come to the microphone, please.
So just to pick up on the standard essential patent points that you were just making, and the requirement to compare the value of the invention outside of its place in the standard, isn't the precise reason that the standard adopted the invention as compared to other competing inventions that accomplish the same thing, isn't that a reflection of its value, that the standard in a competitive way chose that invention?
So I've heard that argument. I've also heard the argument that when you're looking at some standardized technology, you have to take it on a patent by patent basis. So obviously there is a range of actions, but that when you're looking to build a standard, you just need to perform a certain function. And sometimes there are multiple ways of performing that function. And where there are multiple ways of performing that function, you're just trying to get the job done. And so that would sort of argue against the point that you're making, that there should be some competitive benefit for being selected into the standard. Now, like Nate's point on quality, I'm not ignorant of the tremendous amount of academic and other arguments surrounding standard essential patents, the appropriate valuation thereof, et cetera. But I think when you're looking at what the Federal Circuit was saying in Erickson D-Link, they're saying that you want to look at what's happening outside the standard, that there's not actually a benefit that should be created by being included in the standard. And I think when you're looking at that, the proper way to think about that is there are multiple benefits to a SEP holder when their IP is included in the standard that go just beyond the FRAND rate that they would later be able to collect. One of the things is you have the first mover advantage. So when you're trying to build a standard, if you've developed the technology, then you have a better understanding of what's going on. The other is that you may have a competitive benefit in the marketplace when people are deciding what sort of, we have a bunch of implementers, we're all producing to the standard. If I'm the implementer that developed the technology, I may see a benefit in the market that's separate from the FRAND rate that I would later collect from other other implementers.
So just to follow up, would you agree that one could look at what was happening in the development of the standard as a factor in understanding the value that the invention brought, but one would have to be careful not to impute a value to the invention that would be the synergistic effect of it being adopted into the standard?
So I just personally, I wouldn't be able to agree to that, because we've taken the position in the 2011 report that you should look at the value of the technology before it's included in the standard. And I think that's consistent with the position that the court took in Erickson D-Link.
Thank you.
Thank you.
Thank you very much for the question. Any other questions? So there was an entire panel on IPRs, but I think any discussion of appellate review in the patent law would be remiss without talking about the gathering appellate storm that the Federal Circuit and the PTO and litigants are facing with respect to review of IPR decisions. Nate, would you like to comment on that just as we close?
Sure. I mean, I think the slide tells the whole story. I wasn't here for the very beginning of the panel this morning, but I don't think they got into the volume problem. Towards the end, I think it was mentioned about the sheer volume of arguments that are going to be at the Federal Circuit this month. But if you look at this chart, and I know you can't see the actual dates on the chart, what that is a chart of is sort of the input to the AIA trial system. So it's a chart of filings per month on the petition basis. And there's different colors only because it's broken out into CBMs and IPRs and PGRs, but mostly everything you can see is IPRs right now. If you rewind back from today, so you go back and you figure out when a case that's at the Federal Circuit right now, that's going to be argued in April, for example, when that case basically was born, what do you take out? You take out the pendency of the Federal Circuit briefing stage, which to get to an argument right now is pretty quick at the Federal Circuit. It's probably quicker than any other court in the country. Once your briefs are in, it gets put on the calendar. But if you back it out, you see that the briefing period probably takes until argument after notice of appeal, maybe 6 months or so, roughly, right? Some of us like to get a lot of extensions of time every single time we file a brief. So you back that out. You back out the time of the trial, which is a year. Now you're a year and a half back. You back out the petition phase at the PTO, which is another 6 months. So now you're 2 years back. You're basically at the front end of that chart, and you definitely can't see the numbers from where you're sitting, but the numbers start from, I think, under 50 is the first line. They cross 50 right about where the time we are right now. So right about now, if you look at the cases getting argued, those cases were coming into the office when we were seeing about 50 per month, and these are per month filings from the very beginning of the trials. It crossed 50, it crossed 150, and now it's the top ones there are almost at 200. By the way, none of us have figured out why they go up and down and up and down and up and down. There's probably some administrative reason why the past 6 months they've peaked and fallen and peaked and fallen. But we're at a steady clip of about 175 inbound trials per month. The Federal Circuit is now seeing a huge amount of cases out of the PTO, and those cases come from an era when we were only getting 50 a month. It's very easy to forecast a Federal Circuit caseload where the vast majority of cases those judges are looking at are right out of the Patent and Trademark Office. I don't know what their solution is for it, but I'm sure they're thinking about it. We were much anticipating our first few decisions. There's been 8 decisions out of the Federal Circuit now from IPRs, or from, I'll call them AIA trials, and I think so far 7 of them are decided on Rule 36. Which means there has only been one written decision in the first 8, and that was the Quozo decision. But otherwise, the Federal Circuit has been essentially affirming without opinion so far. That doesn't mean there's not going to be some significant opinions written. And our office is intervening in some of them, but not all of them. I think in the early days it makes sense to flush out some issues, but I don't know that that'll keep up. But the wave is coming.
So we haven't talked about the current Supreme Court term. There are 3 patent cases on the docket. One's been decided already, the Teva case involving the standard of review of claim construction decisions, or specifically subsidiary factual findings in claim construction decisions. And the remaining 2 cases will be argued a week tomorrow. We have the Cisco versus Commel case, Commel versus Cisco, and Kimball versus Marvel. A plug for my partners who will be representing the respondents in the Supreme Court in both those cases. Seth Waxman will be arguing for Cisco. And that's a case that, as it first came to the court, involved the defense of a good faith belief of invalidity in induced infringement cases, but thanks to Nate and his colleagues in the government, has widened significantly now, and arguably will touch on the question of whether any kind of good faith belief, including non-infringement, is a defense to an induced infringement charge and to the specific intent requirement to prove induced infringement. Kimball versus Marvel has to do with the vitality of what's known as the Brulat rule, the rule that when you license intellectual property, the royalty stream that is appended to the license cannot extend beyond the date of expiration of the IP. It's an old Supreme Court decision that's now being challenged and my partner Tom Saunders represents Marvel and will be arguing that. So back-to-back patent arguments in the Supreme Court on Tuesday. If you have a free morning, I'm sure you can go over there and get a seat and see the action. And maybe Professor Thomas will have us back next year to talk about the fallout of those decisions, no doubt in late June. Suzanne, Nate, what a pleasure. Thank you so much for your time and your insights. It's been great being on the panel with you. Thank you all for your attention. And let's go hear Congressman Issa.
Sorry to do that to you again. If everyone could go ahead and finish up their conversations, we'll start with the keynote address in a moment. So good afternoon, everyone. My name is Greg Lantier, and I am a IP litigation partner here in Washington, D.C. at WilmerHale. I have the honor today of introducing our keynote speaker. As the name of our conference today suggests, the focus has been on significant changes taking place in patent law. And as our panels discussed this morning, many of those changes have come from the Patent Office itself, from the changing and increasingly interconnected global economy, and from the U.S. Supreme Court and U.S. Court of Appeals for the Federal Circuit. But no entity has had more impact on the changing of the U.S. patent landscape over the last several years than U.S. Congress. With the passage of the America Invents Act in 2011, that marked the most significant modification of the patent system since the passage of the 1952 Act. And our keynote speaker today, Congressman Darrell Issa, was an original co-sponsor of that legislation and worked for 6 years on its passage. Since the AIA's passage, he has co-sponsored additional bills that seek to make further major reforms to the U.S. patent system, including the currently pending Innovation Act, which was reintroduced to the House last month. That proposed legislation, as many of you know, would greatly impact the pleading requirements for patent infringement cases, as well as the timing of invalidity determinations in litigation. Among other reforms, it would also significantly change who pays for patent infringement litigation, when they pay for it, and how much that patent litigation costs. Congressman Issa represents the people of California's 49th Congressional District in the United States House of Representatives. As many of you, I think, already know, he is a member of the House Judiciary Committee and currently serves as chairman of the Subcommittee on Courts, Intellectual Property, and the Internet. He is also chair of the House Foreign Affairs Committee. Congressman Issa comes to patent issues not only as a lawmaker, but also as an inventor. He holds 37 patents of his own, and prior to becoming a member of Congress, was a successful businessman in California, having founded and served as chief executive officer of Directed Electronics. Needless to say, we're very pleased to have the congressman here today joining us as part of this conference. Please join me in welcoming him to the podium and thanking him for providing us with his thoughts on important issues of patent policy.
Well, first of all, please continue eating. I'm absolutely used to hearing clanking and distractions normally from the dais. Yeah, that's right. That was supposed to be the beginning of funny. First of all, I want to let you know that I'm delighted to be here at an institution that would never have admitted me as a student. But I see the smiles out there. A few people are saying, and how did I get here? The fact is that the American Invents Act was the reform of the patent application and litigation process. This is, in fact, a reform of, as the name would imply, the innovation of many of you in the audience. There are no greater innovators in America than a plaintiff's trial lawyer. They have and will continue to innovate no matter what we do, the Fed Circuit does, the Supreme Court does. So from time to time, it's pretty critical for Congress to look and say, are there changes that need to be made? I certainly think that as we continue to look at making patent quality better, we have to equally look at lowering the cost of defending or prosecuting your patent, the fact is we have a problem in America. It's cheaper to pay a troll than it is to defend against a frivolous case. And as Greg said, one of the key elements in the act is, in fact, in the most frivolous of all cases, if the judge determines that, in fact, the case was based on a frivolous pleading, one that lacked an actual fundamental likelihood of, not just likelihood, but underpinning of legitimacy, then the judge shall impose the fee shifting. Now, how many, you're all lawyers here, right? I'm like the only non-lawyer. Just want to make sure. You know, as a businessman, shall and may wouldn't seem to be too big a difference. But of course, we all know that Rule 11 sanctions are may. And as a result, they don't happen. And when they do happen, they don't add up to squat because they often don't cover the cost of your bringing them. We need to change that. If, in fact, you know that you have a claimant who has no merit, or quite frankly, if you're defending your patent in a litigation and the other side is, in fact, bringing equally frivolous claims against you, and I'll touch on that in just a moment, you need the same exact remedy. And I want everyone to understand the intent of the bill is to make sure that both sides have an opportunity to deal with frivolous claims. Now, there probably aren't any hedge funds in the room, but if you were following the hedge fund community, you'd know that one of the new areas that we're seeing that is particularly disturbing is, in fact, using a lawsuit claiming patent invalidity in order to drive down the price of a stock you've already shorted. It is inconceivable to most people who are not SEC lawyers to believe that that isn't already illegal. But it not only isn't illegal, but it's going on as we speak. Someone says, well, you know, I thought the stock was overvalued because I thought that, in fact, their patent was invalid. And then you file the claim, and no matter how frivolous it is, you've had the win you wanted because the stock falls, and you then unload the stock. So it's not just the troll that you see and that many of you in the room expected me to talk about. It's looking at the distortions within our markets that have to be equally part of our ongoing investigation and legislation. Now, Chairman Goodlatte, I think more than anyone else, is driving this piece of legislation. He's driving it through working with the Senate to make sure that this Congress, although we will probably go first, we will not go alone. The expectation from the chairman is very clear. We will not vote it out of the House only to have it languish in the Senate. 325 members of the House, which, by the way, in a body like the one I belong to, is such a majority that you might as well call it unanimous consent. To get that kind of support for a piece of legislation and then have it simply be not picked up, not taken, no alternatives coming back from the Senate is not something that I think we want to have happen twice. And I think for all of you, you realize that to have the will of the people be clearly stated in a vote like that, and then have, if you will, possible objections of the few turn into, well, I can't defend against it on the floor, but if it never comes to the floor, we're okay. So I do expect that you're going to see movement on this bill just after the Easter break, followed by movement in the Senate. I won't take any credit for anything that does or doesn't happen in the Senate, but I will say that Chairman Goodlatte is working hand in hand with one of the men that I admire, and that's Chairman Grassley. He gives us all hope, all of us who serve on judiciary and not attorneys. Before I take questions, I just want to touch on one aspect of legislation that I think people don't begin to fully appreciate, although I think some at this table do. When I entered into business, I didn't know what a patent reexamination was. I didn't know it until I found a patent that was more than a decade old, was held by someone who had been a customer of mine for most of that decade, and nearing it, actually it was almost 2 decades old, nearing its expiration, suddenly was applied to the product that my customer had been buying from me. And while in litigation, the best opportunity I had for a remedy was to send it into re-examination. But you know, re-examination under the old system, or under the current system, but versus post-grant review, has one pitfall. And the pitfall is you send the information in and you hope they understand what you said. You hope that behind closed doors, a patent examiner doesn't simply buy off on what the inventor tells them, some assurance. You hope that they understand what the claims are that they're making in litigation. So I came to Congress many years ago, 14 years ago, understanding that we needed to have the patent office make patents better, and particularly when a patent holder expands his or her interpretation of what they really have long after they've left the process of getting the claims. So one of these forums is best when it comes with questions, and I certainly hope today you all have questions for what few answers I came with. And I'd love to take your questions, unless you want me to do the rest of the speech, because I've got 5 more pages. Yes, sir. That's a great question. Well, first of all, universities should not have protection. Universities are often bullies. Universities are often participating with trolls. Universities are large inventors. They're wealthy. They have a huge amount. They are corporate America as much as General Motors. So the first thing is if a university has a patent portfolio and is licensing it, good for them. And in fact, what we intend to do with the Act is make it quicker for them to get to a markman, quicker for their patent to be evaluated based on its true means. And of course, as all of you that in the audience that are still student would appreciate, in their pleadings, we'd like them to give us the course outline rather than say, well, we'll get to that at the end of the next semester. The bill specifically, if you're an inventor and you see an infringing product, rather than do what, and I left small inventors for a moment aside, but if you're a university and you just want to say, here's 50 or 500 or 5,000 patents, give me royalties because you're infringing one or more of them, shame on you. Tell us what it is that somebody's doing that causes you to send that demand. Tell us what the value of your patent is, what the claims are. And there are 2 reasons for it, and I think they're both important. First of all, it gets us to a markman. It gets us to, in some cases, a review by the patent office quickly. But it also gets us to innovation. If the goal, and that's why I wanted to get to a small inventor, if the goal is innovation, and we will presume in many cases, the university is a multi-billion-dollar entity. Well, I'm the small inventor that they've sent the letter to saying, here's 500 patents and we expect these royalties or you'd better stop your innovation. If they tell me what they have with specificity, they give me the challenge to either pay the royalty, stop producing, or better than that, innovate. Look at what they have and do one better. Look at what they have and innovate around it. I grew up in the radio frequency business, and we had 2 major ways of doing, receivers: super heterodyne, super regenerative. Very different. Originally, both covered by patents, but more importantly, each distinctly different. One working very well, but costing a lot of money. One working, not quite as well, but being dirt cheap. Innovation is often about making that dirt cheap thing because it gets around a patent and then, in fact, supplies a better product. So I think if someone expects me to say, oh yeah, there's all of us and then there's the universities, ain't gonna happen. Universities today often employ troll-type entities, hand them a portfolio and say, send us money. Those troll-type entities had better darn well do a good job, not file frivolous claims, and plead with specificity by claim under this Act. And I say all of this because if we don't honestly say that we expect universities to step up to the plate, then in fact they will continue to say, well, but in the name of universities, you have to give us an exception. I don't think we can, and I don't think we should. The small inventor, and I think that's the second answer that's most important. I was a small inventor. I knew exactly what my patent did and meant. I knew what I gave up during my prosecution of it. I understood what my claims were. Matter of fact, I was acutely aware because I'd fought to try to make sure they were as expansive as can be. But you know what? I also was able to, if someone was infringing, say what it was and why. In some cases, I wouldn't know everything they were infringing until we went into discovery. But why would I sue somebody based on the vague thought that they were making a competing product rather than at least one specific claim that I could say, based on looking at this product or service, that you're doing that? Does that answer your question? Is it the one you wanted? Yes, sir. I may not get invited back to a great research institution in the future, but
thanks. I think most of us were really pleased to hear you point out the abuse that the short selling situation has created. That was filed. That's, well, among other reasons, it's an IPR. It's a post grant process, and I think among other reasons, it may be because of the high invalidation rate at the office, which gives that, I guess, some more certainty.
Well, or at least the high expectation.
That's right.
Because, you know, when we look at many of them, they're actually, I mean, 75 or whatever percent to get taken, a high portion get invalidated. But the reality is that you don't need that if your only goal is to short the stock. All you need is to throw a claim out there. Right. And, you know, and to be honest, I've been in litigation with a public company who simply wanted to be able to keep their stock up and keep selling to General Motors, and the litigation did both of them for them.
Well, the reason I bring it up is because in addition to concern about abuses in the litigation process, there are now starting to come up some questions, maybe even some abuses in the post-grant process. One of your congressional colleagues, Senator Coons, has introduced his own version of this bill, which has some of the things that the House bill has, but it also has 5 or 6 things that would deal with the IPR process, with the post-grant process. My question is the House bill, is Chairman Goodlatte so fixed on the current bill that there won't be any amendments at all or any opportunities to look at other kinds of abuses that the creative lawyers have come up with?
Thank you for that question. My guidance from the chairman, and having been a full committee chairman, I know the importance of what the full committee chairman thinks. My guidance is we pass this with 325 votes. Daryl, don't screw it up. So do I want to be inclusive? Yes. Do I want to consider changes that do not scrap the bill, but in fact may make small changes? Yes. Did Chairman Goodlatte give me a free hand to do it? Yes. But he still wants 325 votes on the floor. So part of what happens, and you'll appreciate this as a Washington insider, there are people who come in who are never going to vote for the bill, and they want changes. And then there are people who come in who are already voting for the bill but would like to make it better. The latter is a group that we want to spend a lot of time with. The former, we really want to spend time with them if it can get them from no to yes, or from no to neutral. And we've been working, Ellen's taken, my staff here has been taking meeting after meeting. I'm taking them for just that reason. What does it take to get somebody to either go from no to neutral or from, you know, a no to yes? And we're making some progress, and that is one of the areas because we do see the potential for manipulation and so on. One of the challenges too, though, is it is so early in the process that you know that the worst patents get in quickly, and they're the ones going through review. Our view is that if we took the entire world of patents, within a couple of years, no matter what the starting number is, it would drop. And it drops for 2 reasons. One is in fact, you've gotten the worst of them out of the system. But the second one, and this is the one that I hope all of you that are working day to day in patents are seeing, which is the PTO is getting the message that if your patent gets out there and then it's crap, and when it comes back in through the IPR, suddenly they go, boy, those guys really screwed up on the examination. If you're a career professional, you don't, it's like being a federal judge and having the Fed Circuit, consistently, or your appropriate circuit, overturn you. You just don't want to do it. You want to be right the first time whenever possible, or make great case law. And so we think patent quality is also the second part of that drop.
Another small change I hope you would consider: your patent pilot program is working very well, certainly in the district courts, but it's underfunded or not really funded at all. If an opportunity to maybe fund that program, clerks, another funding would be great.
Well, it's quasi-funded. People are getting clerks and so on. How many people don't know what a patent pilot program is? Come on, be brave. Raise your hands. Okay, that's enough. I only needed one to explain this program. 17 years ago, I had the great honor and distinction of being the first defendant before a magistrate who was elevated to be an Article III judge. I was his first case. And he's now the senior judge out in San Diego, Judge Moskowitz. And Judge Moskowitz had this case as a magistrate, but he hadn't done very much with it. And the judge who had it was so thrilled when he got his Article III appointment, because then she could get rid of it and dumped it, along with anything else that, all the ash and trash that judges didn't want. Here's this new judge, boom, give it to him. So he got this case, and it had been stalled and had been going for a long time. And so I got to be his first trial. It was shortly after Markman had become the law of the land. And so he did the Markman. I can't remember if we'd actually started picking the jury pool or not, but it was at that point. And so basically simultaneously we begin the case and he makes his Markman. Now his Markman made it clear that I was absolutely positively innocent, that any reasonable interpretation of the invention did not read on my production product at all, not even close. But he'd invested so much time and he was so aware of it that he just, even though he knew that he was going to have to direct a verdict at the end of it all, it's like, yeah, but these men and women are here and they've agreed to do jury duty. So I had 2 more weeks of paying my lawyers. By the way, there's a Baker McKenzie wing in San Diego based on some of my cases. So we completed it, and the jury came in, absolutely. They came in with invalidity and non-infringement. It was just a wonderful, wonderful win. By the way, of a patent that had expired already. I was into a congressional, and by the way, thank you again for saying you didn't know about this so I could tell this story. The Congress had gone from 17 years from granting to 20 years from application. And typical of Congress, the hubris of Congress is they didn't see a problem being retroactive. So this patent got almost 2 years and a month, because it was a very wham kind of a patent. It was just, it went right through. It was like an 11-month patent. So it got an extra 2 years in which I was actually defending a patent that had expired. But thanks to Congress, I was still getting, they couldn't get injunctive relief, but they could still get royalties or, damages if they'd won. So I'm mad at Congress. I'm mad at the judge that didn't take this case. And I am definitely not yet a great friend of Barry Ted Moskowitz, who took me all the way through $1.25 million of total cost. And then I run for Congress. I go, okay, what lessons did I learn? I learned that, in fact, judges who don't like cases shouldn't have them. If you don't want to do patent work, we got to figure out to the greatest extent possible for you to be able to get rid of them, but not dump them on somebody else who is not necessarily prepared, not interested, because that, in fact, almost perpetuates bad results or at least delayed justice. I also learned that judges didn't necessarily have the tools, even if they had the interest. Judge Moskowitz actually had the interest, and he's worked hard to try to be good at it. He's done several more of them. Averill Cohen, who retired out of Detroit, was legendary and I had a case with him. I was a plaintiff there that was much better. I got the $16 million I was entitled to rather than being hurt by the false claims. You notice that, they're false when you win and so meritorious when you're on the other side. But, I was in front of a judge who loved them, who had done a ton of them in Detroit. And I saw what a judge who had really gotten his act together, who didn't take a lot of grief on discovery, who understood the process, that it wasn't the same as every criminal case in front of him. And so when I got to Congress, I started figuring out, okay, what would be the elements? And the first person I went to was Judge Moskowitz and said, Barry, what have you learned? And we made notes. That's what Patent Pilot is an attempt to allow the courts to do certain things, including, as long as they don't number to one predictable judge, to be able to have two or more judges who hear the cases disproportionately. Now, that may not work in the Eastern District, but nothing works in the Eastern District unless you're a plaintiff. But it does seem to be working. We do need to expand it. We need to get off of the idea of it being a pilot. It's clearly something that the courts like, and then wherever applicable, where you have enough judges, it needs to be expanded. And then the second half, which is we have to figure out a way within funding to allow these judges to have the kind of funds. It may be a challenge because it may have to be through fees, not appropriations. And I know that's always controversial, but it may have to be just that way. And I'm looking for ways to do that, because the reason Patent Pilot didn't come with a dollar tag is that I never would have gotten it through, because I would have needed a ton of money. Now, I will tell you that I have one hope. Anyone in here interested in immigration reform? Ellen, you don't count on this. Thank you. I've got one. That's all I needed for the answer. The Skills Visa Act, which was introduced last Congress by a chairman of a different committee, now the chairman of the IP subcommittee, myself, scored $108 billion. If we take out of 1.2 million people who legally immigrate to this country every year, and we just take about 100,000 of those slots and move them to the best and the brightest, people with masters and PhDs, many of them graduates of U.S. universities, it scores $108 billion over 10 years, $500 billion over the next 10 years, and that's not dynamic, that's fixed scoring. That's how much more income tax will get paid as a result of simply picking really smart people to come work here that'll add to our economy. If we pass that bill, certainly judiciary is going to look for places where some of that money could be well spent. And our view is, since we're going to increase by 100,000 the amount of people with science and engineering and math degrees and help an H-1B expansion, that really goes with the innovation of patents. So the hope is that we may be able to take some of those dollars and earmark them in the good way, in other words, authorize them to go toward, if you will, court technical enhancement. It will not be Patent Pilot, but it will be court technical enhancement. And I think, as they say in the Middle East, inshallah, God willing, this will happen. Okay, other questions? By the way, who doesn't like this bill? There's got to be somebody here. Somebody stand up and say, I'm a troll, I'm proud of it, and I want this thing never to go anywhere. Please, somebody. There we go. Thank you. You're going to fake being a troll, I can tell.
I rather like the bill, but one aspect of it that's controversial for many is that there are carve-outs for the pharmaceutical industry. The bill at some point exempts under 71E under the Hatch-Waxman Act. So normally laboring under a one-size-fits-all patent system, other than sort of political realism, what is the rationale?
Political realism. No, it's a great question. Look, bio and pharma don't particularly like this bill, even the way it is. They're one of that group that I'd like to get from no behind the scenes to neutral, so they stop trying to kill it in the Senate and so on. And that's one of our frustrations. I'm from San Diego, and I represent San Diego, and we're known for telecom and bio primarily. And so the bio guys all come in and tell me how awful all of this is, because they absolutely need patent certainty, which is once I've got it, damn it, it's mine, and it means whatever I say it means. Well, you know, even the Constitution doesn't mean whatever someone says it means. It means what is adjudicated through the court system. And so we're already fighting that. So that's one of those battles where I would love to get this closer to one size fits all. Obviously, the first answer I gave on universities is universities, to the extent that they have a patent portfolio and they're out there trying to enforce it, and they're turning it over in some cases to basically funds, and you know, having that separation. We're trying to make sure that they're consistently good actors, and that they understand that if they form an entity, and this is digressing, but I think it's important. This bill says basically if you form a shell corporation that all it does is sue, we're going to pierce the shell, and we're going to the underlying investors, so that you can't simply form something where heads I win, tails there's no fees for us to pay. And we think we've crafted that. We're still going back and forth on language to make sure that we don't have any unfair or fair criticism. But we think it's really important because universities and others are using that technique right now, where the limited partnership that's or other entity that's suing you absolutely is completely, you know, they just walk away from the shell if they lose. We need to make sure that there's an ability to call through. And that's one of the areas in which some people don't like this, because they say, well, how do I, you know, that's not fair to investors. Corporations and LPs are supposed to have a limit. And under our bill, they do, as long as they have some use other than to be used as a conduit to allow litigation with no downside. So that's an area that anyone that hasn't looked at the bill, we welcome your input and any suggestions to make it achieve that goal without any you know, collateral damage to others. Yes, sir.
Last Congress, I think Bio did not support the House bill. I think Pharma did not oppose the House bill.
That's right. They went
neither opposed nor supported. And
yeah, but actually 21st Century behind the scenes just gave us nothing but fits in the Senate. So they were one of those quiet objectors. In case you want to reform the organization, please feel free to get involved.
No, but I think what we're trying to do is get to yes. And one of the things that I just want to drill down a little bit further on,
of course,
was discussed at the morning on these IPRs. The standard of review right now, you know, is preponderant evidence. We have cases now that are involved with analogous to the hedge fund case, where there's been a case that a has been going through federal district court, upheld at the federal circuit on the clear and convincing standard, and now is in an IPR at the lower standard. And so we're hoping to get some changes in the IPR procedure, the standard, and we also the BRI provision that's in the bill, which, but we would also like some further work and refinement on the clear and convincing.
And those are words that Ellen and the team are really working to try to make sure we get it as acceptable as possible. The one challenge that anyone that's worked with the PTO understands is that the PTO's interpretation of what you get as a claim is in fact different than the courts and always will be. And I think that's one of the challenges is anytime you're going back to the patent office, they have to have the ability to view the invention based both on what you're saying now that you got the patent, which is obviously additional input, and the fair reading of prior art. But we are looking to see if there's nuanced words that can make it better, and we're working with all the groups. You know, even knowing groups that are clearly, at least behind the scenes, a hell no, we're trying to meet with all of them and trying to get them to seeing the better angels that are in the bill and getting to a neutral, or in some cases, if we can, to a yes. So we're and please feel free to engage directly, because one of the problems with some of the coalitions, and I've been working with the 21st century, basically I've been working with 3M and their partners, okay, since I started in Congress, and we started trying to do patent reform nearly 14 years ago. And it's always been frustrating that some things, such as the 3M's portfolio system kind of always creep into the process. And I can't make a patent case good for a business plan. I can't say to 3M or to Qualcomm or Kodak or AT&T, you can look at all the people that have large portfolios over the years and say, you can keep the business practice you have. I have to say, if you only had one patent, what would be fair? And that's one of the challenges. And Qualcomm's my hometown favorite, but they have historically been able to say, you know, we're not sure which patent is going to catch you, but we've got enough of them that one of them will. And, you know, our point is you can license your entire portfolio under any terms you want, but if you're going to try to enforce something, even in a demand letter, we want you to have sufficient specificity that the would-be inventor has a real opportunity to innovate. And I think for all of us, that there are two principles that I've always had a hard time with as an inventor. One is I don't want the patent office to assume every inventor is entitled to a patent. At some point, I want them to, you know, an examiner to say, you know, we've shredded with prior art so much of what you say that maybe you're better off not getting any claims granted because they're going to be so narrow as to mean nothing. Because those are often the patents that end out there that suddenly the guy thinks he has something, he sells it to somebody, goes around suing. And so I want to get past that. I want to get to people understanding that, of course, you're entitled to your real inventive innovation, but at the same time, you want to have a patent that has some real quality to it. That's one of my challenges. The other one is the idea that a patent is all about injunction. All of us have to realize patents exist as an incentive for the creations to advance our society. And they get it by both eventually being in the public domain and by their being put down in a way in which people can choose to use them or to design around them. And having been an inventor, many of my claims and my, you know, thousands of claims out of 37 patents, or hundreds at least, a great many of them I looked at prior art and I really did say, can I get something that's patentable and, oh, by the way, a good idea for my industry? And if I hadn't had the prior art to read on, I probably would have invented the same way they invented. But because I saw it and knew that it was either non-patentable or, in fact, infringing, I designed around it. That's part of what I want the patent office to encourage people to do, and I want litigation to allow them to do. Yes, sir. Are you talking about litigation? Okay. Having been an inventor, all we're asking for is for you to fairly read what the words of your patent give you, fairly look at the elements that are necessary to enforce that patent, look at the product, does it have those elements, and within an external look, based on the knowledge you can glean without further discovery, state why it is you believe there's infringement. If you do that, and we've talked with a lot of small inventors about how we would make sure both in the actual letter of the law and in the report language that so often determines people's interpretation, what that standard is. I do not want this to be used to reverse the fees on somebody who said, look, your product does what my product does. I can see that you have these elements, and therefore, from everything I know, here's my here's why I'm suing you. I want that to be a low standard, but I want it to be with the specificity available to the inventor or the assignee at the time of the pleading. That's all we're really looking for. It does, you know, to be honest, we're doing a belt and suspenders, because fee shifting mostly is going to happen when you falsely state the claim construction that you're basing your claim on. Because since we're asking you to plead with, you know, independent claim 1, dependent claim 2, et cetera, once you do that, as long as you're honest on it, and the two read in a way in which any reasonable person would say, well, at least there's a possibility, you're probably clear as can be. That's the whole goal. Let me give you an example, though, and we'll go back to, this happened to be the same case with Judge Moskowitz. The people who sued me had a patent that specifically said one of the elements, and it was means plus function claim to make it even harder to believe they did it when they used to do those. It had a relay in the normally open position, and it described and showed in the picture a coil and set of contacts. So normally open relay. My product had a normally closed relay, which if you unplug the product, you could drive the car away. You needed electrical power in order to break that contact, and I did so specifically so that if my product failed, it might not be as anti-theft, but you could drive the car. His product, if it failed, if power failed for any reason, you had to call a tow truck. And if you connected it to the ignition, your car would die going down the road. Couldn't have been more different. He sued, and even though he had no inside information, he said, but inside this guy's microprocessor, he does what I do. And I'm entitled under some broad theoretical interpretation of the doctrine of equivalence. It was in there and he could have it. He was wrong on means plus function. He was definitely wrong on it being in there. It wasn't in there. Judge Moskowitz reached that point at the end. The problem is, frivolously, he had taken me through hundreds and hundreds of thousands of dollars. And there was no ramification, no anything for this absolutely, because they didn't have the proof when they actually got there. But of course, the proof came with the markman rather than at least being held. What is the old biblical expression? Hoisted on your own petard. Okay, he never had to do anything but say it's in there, and the judge didn't know enough to say, hey, you know, it's time to fish or cut bait. Show us where it's in there. So that's what we're trying to achieve. The fee shifting as a plaintiff is going to be only really if you falsely or unreasonably made those claims. Does that answer your question? Okay, I'm getting this, and I promise to be funny, so I'll end with this. Thank you.
Okay, while the desserts are being handed out, let me offer a few words of parting. First, I've heard two fabulous keynote speeches on patents, one by Todd Dickinson and the one now just by Mr. Isa. Thanks again for coming. Very much appreciated. All right. So first, I should announce that my diligent colleagues went through the auditorium and found not one, not two, but 6 coats left in the auditorium. So if you're missing a coat, it's possibly sitting on the coat rack in the back, and it's in the numbered 440s. There's a little hang tag associated with that. We also found 1 black bag. So if you're missing a black bag, you can claim that as well in the back. Now, I should also tell you, remember the tall chap with the tag who was handing around the microphone earlier? His name is Tim. And if you have any CLE problems, Tim is the one to spell. There he is. There you go. Thanks a lot. I'm glad that Tim is going to do it and not me. So I'm very grateful for that. I had a great time at this conference. I think we had 3 crackerjack panels and a great keynote speech. So we've done 3 of these conferences now. I think this is the best one yet. I'm incredibly grateful to our colleagues at WilmerHale who help us out so much every year and make us look so good. We have to do so little work to pull off a fabulous conference because they do all the heavy lifting. I have to my students, there is something as a free lunch. So look at what you're getting here. And if this is your first time to Georgetown, we rarely eat like this. I tell you, this isn't an everyday thing. We're usually doing Taco Tuesday at the cafeteria. I'd also like to thank the WilmerHale staff. You may have noticed this. There's a very pregnant person and her colleagues in the back table, and it's the WilmerHale special events staff has come from Boston. They've really done all the stuff. So let's have a round of applause for the young people in the back. Just let me close after, I think it's almost been, I'm getting on 20 years on legal academia, believe it or not. And one thing I've learned is that a law school is only as strong as its friends. So I'm really grateful to all of our speakers, to our sponsor, and all the efforts that have been undertaken to make this day a success. Please sit around and enjoy your dessert and be on the lookout. We'll have conferences in the future. We hope to see you here at Georgetown again. All right, thanks a lot and enjoy the rest of your meal. Cheers.